Everyone. Thank you for joining us for the Blue Ribbon Commission on the Future of the California Bar Exam. This is our regularly scheduled meeting for Thursday, October 13th, 2022. Why don't we begin with taking roll?
Susan Bakshian.
Present.
David Boyd.
Present.
Alex Chan.
Present.
Charles Dugan.
Present.
Jeremy Evans. Jeremy Evans. Jackie Gardina.
Here.
Ryan Harrison. Dr. Henderson.
I'm here, thanks.
Esther Lynn. Tracy Montez. Judge Reeser.
Present.
Natalie Rodriguez.
Present.
Kristen Mosey.
Present.
Emily Scavalletto.
Present.
Karen Silverman.
Present.
Mylyn Spencer. Amy Williams. And back to Jeremy Evans.
I'm here. Thank you.
We have a quorum.
Great, thank you. I'm going to take just a quick moment on Chair's remarks. I like to try to give a little bit of a foreshadow of what the meeting's going to look like, and then we'll move to public comment. I want to just thank all my colleagues for the hard work of our last meeting. We covered some really important topics, discussion that has quite a bit of complexity to it. So I know it went a little longer than people wanted, and I apologize for that, but I appreciate everybody's efforts. I think as folks will remember, we were very close to coming to some kind of consensus as a group, but nevertheless, there was a lot of concern, as there should be, around moving forward with any kind of non-exam alternative. I think a lot of the concern was around assessments and supervised practice, fairness and equity, and we then turned to whether or not we were ready to move and completely forego a non-exam alternative, and we were not able to meet consensus there either. And so what we'd like to do today is Amy Nunez, Audrey Ching, and Donna Hershkovitz will walk us through a couple of the items that I think were most important to this group around assessments and supervised practice. Dig a little more into the details of some of the programs that we have talked about previously and how they've dealt with those issues. And specifically, there's even been, I believe in Oregon, some additional information that's been raised since our last meeting. Then we will turn back to trying to figure out if this group can agree on some kind of road and path forward in this area. And ultimately, if we have time, we will move on to out-of-state and out-of-country licensing that is still pending for us. So that's the roadmap for today. With that, let's go ahead and move to public comment.
We have two members, 3 and 4 members of the public that wish to make a public comment. So we will start with Joe.
Joe, if you unmute your mic, I believe you'll be able to speak.
Hi, Joe, you've been given the mic.
Devin, let's go ahead and move on.
Okay.
Thank you.
Next public comment is from Ray.
Hi, I assume you can hear me okay, I hope.
can.
Thank you. I see the heads nodding, it's great.
My big concern here is I sent comments in a couple of times to the Blue Ribbon Commission, and I just would love, okay, so I'm seeing heads nod there. So I assume everybody's got them. I'll make that assumption. Unlike the military use of assume. Anyway, so what I want to ask here, there's a question for everybody to consider, because I know we're not going to be talking back and forth on this. But I'm looking at the California bar public release of information on people who get disbarred. I'm assuming that every single one of those disbarred attorneys had passed a bar exam somewhere or another along the way. I have over 30 years in litigation support. All of my clients are attorneys, local, state, federal, and from other nations. And I have a lot of time in working on a lot of cases, some of which you've probably heard of, and I won't waste your time with that. The other thing is that in my experience with the litigation support, I would be one of those people that say, what, you couldn't pass the bar exam? There must be something wrong with you. I've sat for the California bar exam 6 times. I imagine a couple of times there was something wrong with me. I know in October 2020, based on the answers I got back, all of the formatting was removed, different fonts, different font sizes. ExamSoft ate my answers. They look so bad, I don't want to look at them. In July 2021, ExamSoft destroyed my answers so badly that California Bar did something that they never ever do. They handed my money back to me. The other thing is that California Bar is the point between the general public protection and the minimum competency, which I find laughable, of newly licensed lawyers. My perspective has always been, and if in case nobody read anything I wrote.
Excuse me, you have 30 seconds remaining.
Yeah, let me be quick on this. The fact of the matter is that, and it's in one of the slides on the NCBE recent thing, is that prepping for the bar exam is prepping for working with clients, all right? Something to that effect, if you saw it. The California Bar is the de facto knowledge expert of what it is that newly licensed lawyers need to be to prevent themselves from becoming disbarred in public information. My example in my discussions that I had written up explain that. And I just want on the record that I hope that everybody gets a chance to look at that. California Bar does great presentations. I was part of one of them, and I love there's great different people on a Zoom meeting in different locations did a fabulous presentation. California Bar should be the educational master of getting us to be far in excess of minimal competence. I appreciate your time. Thank you very much.
Thank you. Next public comment is from Mark.
Good morning, everybody. Thank you for allowing me to speak a moment. My name's Mark. I've been an attorney here in California since 1996, practicing criminal defense and cannabis law. And I'm speaking today with regards to my personal experience with a PLL that I've been supervising, not only since 2020 when it started, but when this kid came out of college, moved from Tennessee to go to law school in California because of what he saw us doing in the criminal justice realm, and interned for me through law school, and while he was and is still going to study for the bar. And he has logged over 5,000 hours of work as an attorney. He has appeared over 300 times by himself because he soaked everything up that I taught him, as he was by my side for a lot of it in court, watching me do what I do. And somebody like that, there's many candidates out that, from what I understand, in this PLL, this first group at least. And I'm also a 3-time bar taker. And, I couldn't tell one way or the other why I failed the first versus the third and the third time I passed. And I think it's very outdated at this point. And my PLL has proven himself as he teaches attorneys he's meeting in court, doing his criminal defense motions, teaching them what's going on and what to do. A new law was enacted in California that Newsom signed not so long ago that allowed most misdemeanors to be judicially diverted.
You have 30 seconds remaining.
Many of the attorneys that I've seen over the years in my practice, and as I say, 10, 15 years in, don't have half the knowledge that he does. And I think these PLLs are driven to really prove what they can do. And the ones who can't, if you have good supervising attorneys, I think that's what it really comes down to, is the supervising attorney staying right on top of everything. And if someone doesn't cut the mustard, then they're out. That's all I have to say. Thank you for the time.
Thank you.
Devin, before you call the next one, I just want to, I'm remiss and want to remind the public that we asked you try to limit your comments to 2 minutes. As to the first speaker, I do want to say that the commission has received all of the written public comment that has been sent to the bar, and it's been distributed to the members. And I thank you for those. Go ahead. Thank you.
Our next comment is from Claire.
Good morning. This is Claire Solat from the Legal Service Funders Network. It's a pleasure to be with all of you once again. When I last was able to address this group, I gave you a little highlight of upcoming activities and events at the LSFN, including our midterm evaluations. I've sent in a brief summary that hopefully you've all had a chance to receive, but I'm going to use a couple of my precious time, a couple moments of my precious time to give you a few highlights that specifically address several of the issues that you're going to work on today. First has to do with supervision. From both our LSO hosts and our fellows, over 95% felt that the supervision being received was extremely good, that the fellows were capable of doing meaningful tasks, that their time was well used, and that the capacity to serve clients had been significantly increased because of the work of our fellows. In addition, another comment that's come forward that people are curious about is the equity in terms of who gets to have these supervised positions. In our fellowship, over 75% of our fellows come from non-traditional backgrounds, meaning that they are BIPOC, they are first in family, often to graduate from high school. Many are identifying as queer or single parents. And we have absolutely no doubt that the biggest users of a pathway are going to be folks like this who are not attending law schools that have 90% plus pass rates, but in fact, they will be people from law schools, both ABA accredited and California law schools.
30 seconds remaining.
Lower pass rates and more challenges taking a bar exam. I'm going to use the last portion of my time to highlight some of the written comment that I've sent in addition to other LSFN members. So previously, a written comment was sent in from the Walter S. Johnson Foundation saying that funding this type of program would in fact meet its mission and they would be excited to continue to participate. And recently, you've also received a public comment letter from the California Access to Justice Commission also.
I'm sorry, but your time is up.
How helpful a program like this would be on access to justice. Thank you so much.
Thank you. Our next public comment is from Kendra.
Hello, and thank you for allowing me to publicly comment on this situation. I am a part of Disability Rights California in the Civil Rights Group, and we believe this Disability Employment Month, we have the obligation to ensure that the legal profession creates solutions to the barriers faced throughout a disabled individual's journey to becoming an attorney. The empirical data should really be used to evaluate these arguments that seek to maintain the status quo of qualifying for the legal profession. As the evidence illustrates, there is a need for expansion of solutions regarding diversity, equity, and inclusion. When we look at the microcosm of the legal profession in California, the newest information shows that only 6% of attorneys are disabled, and nationwide, only 1.2% of attorneys are disabled, while in reality, almost 18% to 26% of the general US population is estimated to have a disability. In addition, the large majority of people who need legal services are from these marginalized populations, including those with disabilities. Disabled community members and disabled lawyers are a huge asset to the legal field,
30
as
seconds
disabled
remaining.
individuals have the innovation, creativity, and dedication to serving these marginalized communities in the legal profession. We believe because such a large percentage of the California population is disabled, their lived experience can better shape the law of disability legal issues here and are vital to reconstructing the barriers opposed in not providing any alternatives but the bar. Thank you so much for your time.
Thank you. Our next public comment is from Selena.
Thank you. Are you able to hear me okay?
We can, thank you.
Fantastic. Hi, good morning, everybody. I'm Selena Copeland, Executive Director of the Legal Aid Association of California, and I've spoken with many of you over the years on legal aid issues. And LAC urges the Blue Ribbon Commission to include in its recommendations to the State Bar Board of Trustees a recommendation to explore non-exam pathways to licensure. I'll keep my comments brief, but we recognize that the State Bar needs to continue to have a gatekeeper function to ensure that all of its licensees are qualified to practice law. But we don't think that bar exam is the right gate for all law school graduates. I know, as we've already heard, many disability rights advocates will or have commented today and in past meetings on their concerns about the accessibility of the existing bar exam and whether judging someone's competency for their entire career over a 2-day sit-down exam is appropriate. You've also heard critiques from many presenters about diversity, equity, and inclusion challenges with the current bar exam and whether an alternative pathway would increase the pipeline to have more attorneys coming from diverse backgrounds. What I'm most aware of, though, and what's my area of expertise, and what I urge you to consider, is that we have an incredible shortage of legal aid attorneys in our state. I'd heard from many organizations that their hiring pools have dried up due to inflation, and the cost of living has risen so high in our state that the old legal aid salaries just aren't enough. And so while our community is working to raise salaries, we're still faced with a smaller pool of people who are able to take significant time off of work, unpaid, to study for and take the California bar exam. And sometimes, as we've heard multiple times.
30 seconds.
Thank you. In your recommendations, I urge you to recommend the creation of a working group specifically for implementation of designing a pathway for graduates from ABA accredited law schools across our country and graduates of California accredited law schools. I also think it's incredibly reasonable and prudent to consider rolling it out in iterations, starting perhaps with legal aid organizations that are already monitored by the State Bar and with government entities. I have many thoughts on how a program could be designed to center client needs and client communities while also engaging new graduates and making sure that they have supervision, mentorship, and skills building to become amazing advocates. And I'd be happy to engage our community more in a later working group process. And I think that this is just really important that a working group include people who are experts in—
I'm sorry, but your time is up.
Great, access to justice and legal aid. Thank you so much.
Thank you. Next public comment is from Patrick Quinn.
Good morning, everybody. Thank you for your time this morning. My name is Patrick Quinn. I'm currently provisionally licensed under the Provisional License Program. I've been provisionally licensed since December 9th of 2020. I have spoken to the public a few times previously, and my supervising attorney, Mark Warselman, actually just spoke. I feel very privileged to have a supervising attorney as Mark that has made sure that becoming a provisionally licensed lawyer was, afforded to me and supported. He's also been there for the last, as he described, many years previous. From my experience, I know a few other provisionally licensed lawyers, one now that is currently fully admitted, that had the same kind of experience that I've experienced. We worked really hard in law school to build a relationship with a law office. We did legal work through our law school with the law office. And during this weird time of COVID, became provisionally licensed for one reason or another. My personal reason was due to health reasons. I suffered 2 grand mal seizures shortly after graduating law school, which altered my life completely. The provisional license program allowed me to log several thousand hours and do several hundred appearances and really become up to date on the most modern penal codes. And I've had great success in the courtroom, and I'm just very thankful. So I just urge the Blue Ribbon Commission just to think about all the different types of, people that would be applying for this that wouldn't else have the opportunities as discussed as being disabled and, health reasons, etc. I think it's very important that the supervised license program or the provisionally licensed program and the supervisors are the most to consider, because the supervisors are the ones to ensure the provisionally licensed lawyer is competent and does their duties as according. I just also wanted to just say thank you so much for even contemplating this program. Thank you for your work for the past year or so. I just wanted to say thank you. I waive the rest of my time and wish everybody a blessed week.
Thank you. And circling back to Joe for our last public comment. Joe, you have the mic. I'm not hearing anything, so it perhaps is a mistake. So with that, we have no more public comments.
Okay, great. Thank you, Devin. And thank you to those that shared public comment today. I think next is for us to go through the approval of the minutes. We have revised minutes from July 19th. There were a couple of, it was pointed out that there were a couple of items that were not included in the July 19th minutes. They've been revised. And then the August 16th. I think, Devin, do we need to take them separately?
We do.
Okay, so let's go ahead and do I have a motion on approval of the July 19th minutes?
So moved.
I'll second.
Thank you.
Roll call vote. Susan Bakshian,
Approved.
David Boyd,
Aye.
Alex Chan,
Yes.
Charles Dugan,
Approved.
Jeremy Evans, Jackie Gardina,
Approved.
Ryan Harrison, Dr. Henderson,
Approved.
Esther Lynn, Tracy Montez,
Approved.
Judge Racer,
Approve.
Natalie Rodriguez,
Approved.
Kristen Rossi,
Approved.
Emily Scavalletto,
Approved.
Karen Silverman,
Approved.
Mylen Spencer,
Approved.
Amy Williams,
Approved.
and back to Jeremy Evans. The motion passes.
Okay, great. Thank you. Let's move then to the August 16th, 2022 meeting minutes. Do I have a motion for approval of those minutes?
So moved.
I'll second.
Let's go ahead and do a vote, please.
Susan Bakshian,
Approved.
David Boyd,
Approved.
Alex Chan,
Yes.
Charles Dugan,
Approved.
Jeremy Evans, Jackie Gardina,
Approved.
Ryan Harrison, Dr. Henderson,
Approved.
Esther Lynn, Tracy Montez,
Approved.
Judge Reeser,
Approve.
Natalie Rodriguez,
Approved.
Kristen Rossi,
Approved.
Emily Scavalletto,
Approved.
Karen Silverman,
Approved.
Mylen Spencer,
Approved.
and Amy Williams. The motion passes.
Great. Thank you, Devin. Okay, let's go ahead and move to the business portion of our agenda for today's meeting. First topic is the discussion and recommendation for our California non-exam pathway to licensure. I believe we're going to start with Audrey Ching, who's going to talk to us a little bit about assessments in Canada's prep program, and then we'll move to Donna, who's going to spend a few minutes on supervised practice, and then we'll open up for discussion.
That's exactly right. Thanks, Josh. I'm going to share my screen.
and we're kind of recap a little bit and then go into some more info on assessments and supervised practice. So where we are today, we're discussing this California bar exam alternative. We've heard presentations again from some bar exam reform experts, Deborah Merritt, Joan Howarth, the Daniel Webster Scholars Honors Program out of the University of New Hampshire, Wisconsin on diploma privilege, the Oregon Task Force that's putting forward an Oregon experiential pathway and a supervised practice program. We've heard from Canadian provinces. We had Alberta, British Columbia, Ontario come several times, and then also the PrEP program used by 4 provinces. So we've heard from all these speakers in the past. In July, and we just went over those July minutes, we moved forward 3 options for consideration, which are kind of teased out more in the posted agenda item. Option 1 was not changing the program of legal education, not changing the unit requirements, but the 6 required experiential units would be modified to meet the CAPA requirements for skills and abilities. That would be combined with a post-graduation supervised practice period between 750 and 1,500 hours. And then at the end, a summative portfolio reviewed and scored by the regulator. Option 2 was more like the Daniel Webster Scholars Program, with the bar exam alternative introduced during law school with an expanded doctrinal and experiential education requirement modified to reflect CAPA. This option would increase the requirements, add a state bar regulated curricular path for California law schools that would diverge at some point from the standard law school curriculum. It would have externships, practica, simulations, and clinics. This option would also have supervised practice after graduation. And then at the end of supervised practice, a summative portfolio to be scored by the regulator. Option 3 was no change in law school except for the 6 experiential units already required to be modified to meet the CAPA requirements. Supervised practice with those same number of hours considered, and then a California PrEP program like the one used in several Canadian provinces with online modules, in-person workshops, simulated law firm, and an in-person capstone. So that's just sort of where we were going into the August meeting with these options that we looked at. All of these options have 3 components: what happens in law school, supervised practice, and assessment. So I'm going to start with teasing out a little more of these components. So we looked at law schools either not really changing the program of legal education or changing it and having a bar exam alternative pathway that starts in law school and expanding those doctrinal and experiential education requirements. So those are sort of the choices there. And then assessment. So in the ones we move forward, we had a choice of summative portfolio at the conclusion of supervised practice. We had a choice that would consider this California PrEP program with modules and workshops and capstone in a simulated law firm, or we can still look at other models with other types of assessments. And that's what I'm gonna, so that's all recap. We've seen some of these slides before. And now we're gonna look a little closer at the Ontario assessment. So we've had Ontario come present, and they have the articling program as one of the major components of their how do they get called to the bar or how they become licensed in Ontario. But they also have exams still. They have the barrister and solicitor exams. So the licensing exams are self-study, they're multiple choice, they're open book, both of them. And they test the barrister competencies and the solicitor competencies. And those are kind of covered on the slide. I'm far from an expert on what those competencies are, but they are 2 separate exams. The barrister one covering some different items from the solicitor one, both of them sort of delivered in the same way, which are open book and multiple choice, and they test what they believe in Ontario to be these competencies required for entry-level practice that have the most direct impact on protection of the public and influence an effective and ethical practice. So these 2 exams that they have in Ontario can be taken at any time in the licensing process, and they can also retake them if they don't pass. The exams are 4 hours and 30 minutes long, each of them. So there's 2 separate exams. Each of them, you have up to 4 hours and 30 minutes, 160 multiple choice items, and then they get kind of broken down by these sections on the prior slide. So they get broken down by ethical and professional responsibilities, knowledge of the law, maintaining the barrister-client relationship, or with the solicitor exam, the solicitor-client relationship. So they're kind of broken up in each test. The Law Society of Ontario gives all the online study materials to the licensees. They can print them, they can mark them up, they can bring them into the test area. It's completely open book. They have returned this year in 2022 to an in-person administration of the exam, but these exams have been delivered online in the past. So these are required for licensure, and that differs than some of the other Canadian provinces that we have heard from. So I wanted to dive a little more deeply into these assessments that are part of the experiential education and the articling in Ontario, two required exams. So we just haven't talked about them in depth, so thought it would be good to do that today. What we have heard from and we have posted is also the PREP program, which is the Practice Readiness Education Program. It's delivered by the Canadian Centre for Professional Legal Education, and it's used to determine a minimum competence to be called to the bar. Again, that's what they call being licensed in Canada, in Alberta, Manitoba, Nova Scotia, and Saskatchewan. So this program is designed to be conducted concurrently during articling, or what we're calling supervised practice. So this is and sort of not a perfect graphic image here on the slide, so hopefully you can read it. These are all the different phases. And again, the candidates or applicants who are looking to be called to the bar are doing all these phases alongside their articling. So I'll go through each of these phases now. There's what they call pro certas, which is making sure that their future licensed attorneys know the word processing skills that they need to continue the rest of the prep program, but also to be trained lawyers. So the pro certas, they have to achieve qualified or expert certification in all these Microsoft Suite programs. And these are just online programs they do in Word, Excel, PowerPoint, Adobe Acrobat, making sure that they can have these skills in the rest of the prep program that are required, and then also when they are licensed. And then they have these modules. It's about 110 hours to complete them. There's quizzes at the end of each module. They can retake quizzes, I believe up to 3 times. You know, it's more competency based. And even if they don't pass after 3 quizzes, they can go back and retake like a multi-part quiz. They're self-directed, interactive, multimedia learning, and they have a foundation for all those competencies that are going to be tested in the final capstone. So these are all the modules: the effective lawyer, professional ethics and character, Indigenous law, cultures and people, oral communication related to the client relationship management, oral communication related to interviewing, oral communication related to negotiating, oral communication related to advocacy, legal research, fact gathering and case management, written communication, legal writing, written communication, legal drafting, practice management and trust accounting, technology skills and tools for lawyers, lawyer skills and action, and practice management and action. So these are things they kind of do self-paced alongside when they're doing their articling, all these different modules that they need to kind of pass with quizzes at the end. And then they do foundation workshops, and all the principals or the supervisors in the articling program know that there's going to be this 5-day workshop period where they're not going to be working in their supervised practice articling period. They're going to come together in person. They're going to interact with facilitators. They're going to do workshops that are role playing, interviewing, negotiating, advocacy, again, kind of putting more into practice what they learned in those modules, integrating all the knowledge and skills in a social environment, hearing from their peers, hearing from experienced lawyers, and then, yes, applying what they learned in the modules. And then another online experience called Virtual Law Firm, which they have 3 months to complete. So they kind of do a rotation in different areas: business law, criminal law, family law, real estate. And they have assignments in an LMS, a learning management system, related to each of those rotations. So they kind of get these practice area experts, practice managers, assessing their skills, their knowledge, the progress as soon as they complete each task related to the rotation. They get coaching and mentoring from a practice manager for each of those series of rotations as well. And then finally, this is all in person again. They're not working during this part. There's an in-person capstone. They come together, they put everything together from all the different competencies and all the different programs. and they are assessed in person to see if they have entry-level competence. It's a 4-day intensive simulation, 32 hours, so 4 full days, and then they have to demonstrate entry-level competence to be able to finish the prep program, finish the capstone, and become called to the bar. So we hadn't gone over in depth some of these areas of assessment related to the Canadian models we've talked about. So I wanted to bring those to light to you, and I'm going to hand it over to Donna to talk about Oregon and portfolio review. Do you want me to leave this up, Donna?
Nope. So I just want to sort of bring us up one level for just a quick second. As staff were sort of talking about the last couple of meetings, one of the discussion points that that I think everyone was talking through was with regard to assessments, was whether and how there would be able to be an objective determination of whether somebody possesses minimum competence, right? That was the question mark, I think, for some, right? We've got the bar exam, we understand how that's graded, but how would there be an objective measure if you don't have a traditional bar exam and in fact have a supervised practice program? So obviously Audrey led us through some of the exam options that could exist with in an alternative pathway. In addition, there are objective measurements that can be performed by the regulator looking at a portfolio of work completed during supervised practice. And so that's what I wanted to talk a little bit about. I've took a bunch of notes and tried to pare them down and was not all that successful. One, because I talk a lot, but two, because I think they're just helpful to understand how this could be done. I don't think the specifics are relevant in terms of, I wouldn't expect this commission to design the specifics of what these objective measures would be, what these rubrics would be, but just to understand that there are options and models that we could follow should you decide to choose an alternative pathway to licensure. There are ways to do this. In particular, what I looked at was the Oregon Provisional Licensure Program. So Oregon just implemented a provisional licensure program because of an issue that they had in their February bar exam. As I understand it, there was no heat in the facility where the bar exam was administered. And they were fearful that that impacted people's ability to pass the exam. So they created this provisional licensure program. I think because they were sort of on the way to creating their experiential pathway and supervised practice program, they had thought through a lot of these questions about how you would measure somebody's minimum competence. And so they were able to put together a program, and all this information is available on their website, where they set out specific portfolio or assignment requirements that would be judged or assessed by the regulator. And Debbie Merritt talked to us about some of these as they were in the planning process. But now that everything's sort of up and posted and I've been able to review them, I just want to walk you through some of it. So in Oregon, in this program, the participant in the program has to provide in their portfolio at least 8 independently authored pieces of written work, with at least two of those pieces of written work exceeding 1,500 words. They need to have served as the leader of at least 2 initial client interviews or counseling sessions, as well as served as the leader of at least 2 negotiations. Understanding that some work may not lend itself to client counseling or interviewing or negotiation, then the regulator would arrange for simulations. And there are easy enough ways to figure out how that might be done. I'm told that there are ABA competitions every year in negotiation and client counseling. Those could be mirrored. For negotiations, you can pair the supervisees against one another and have them negotiate on one another to do that, the objective assessment on that. But so under the program, right, so we've got these 8 independently authored pieces. You've got these client interviews, client counseling, and negotiations. What happens with them? Supervisors are required to complete specific rubrics for each item that's submitted for the portfolio. There are 2 types of rubrics that are created for written work products, one for contracts, leases, and other such documents, one for emails, motions, memos, and the like. There's also a rubric created for the supervisor to assess the client counseling sessions and client interviews, as well as for assessing the negotiations. So just as an example, to put a little bit more meat on the bones on what the rubric for the supervisor to assess emails, motions, memos, and similar documents are about, the rubric explores how the participant performed on issue identification, an accurate statement or analysis of the relevant legal principles that are presented, how the participant applies legal principles to the specific facts, whether the document was focused, the organization of the written product, was there appropriate consideration of the audience, and a couple of other factors that the supervisor is assessing. There are also documents that the participants are required to complete for each of the written work products or client counseling, interview, or negotiation sessions, in which they reflect on the work that they had done. But in addition to the feedback from supervisors and participants, I think in response to the discussion that we had at the last meeting, probably more importantly, in Oregon, the Board of Bar Examiners, and I'll just refer to that as the regulator going forward, the regulator scores each of the work products based on established rubrics that the regulators have to analyze each of them. The participant must receive a qualified score on each of the written work products or client counseling sessions, negotiations, etc., in order to be eligible for admission to the bar, along with, of course, meeting all of the other requirements for admission to a bar, like passage of the MPRE and a positive moral character. So the Oregon program envisions quarterly submissions by the applicants of the portfolio to the regulator. The quarterly submissions would include the documents created, the new documents created, would include the supervisor's evaluation, and their rubric would include the participants' reflections on it. One of the reasons that they have the quarterly submission of the portfolios is that they are giving the participants an opportunity. If they submit a document which does not receive a qualified rating, gives them an opportunity to supplement the submission in a subsequent quarter, or replace that item in the portfolio with another. They may also have submitted documents to the supervisor that the supervisor assessed, gave a low assessment to, in which case they wouldn't have included that most likely in the portfolio. They wait until they learn more and do a better document, gets a better analysis from the supervisor that they think will set them up, better position them for a qualified rating by the regulator. So the regulators or the graders rubric for, again, going back to that same example of emails, memos, and motions, it uses the same categories that the one for the supervisor did. But the grader is looking at each category and deciding whether the work product reflects that the participant is working toward minimum competence, has achieved minimum competence, or exceeds minimum competence. If all of the elements that they are required to rate in the rubric are identified as achieving or exceeding minimum competence, and the document is qualified, right? And as I had said, all documents need to be qualified. There are similar things for client counseling sessions and negotiations. The rubrics are instead of rubrics for the regulators, they are basically asking they're looking at the supervising attorney's rubric and the participant's rubric and saying, and asking the Board of Bar Examiners is asked, based on the review of those documents from the supervisor and the participant, would you allow the participant to conduct an unsupervised initial client interview, client counseling, negotiation in their practice area? If yes, qualified. If no, then not qualified, and they would need to submit another one. So just sort of, again, looking at some elements that there are things that we can use as models if you choose to recommend an alternative pathway, ways that there can be objective assessments. One of the questions that came up, and I'm going to refer back to something I said earlier, in terms of the description that I gave you of the written work products, I said it needed to be an independently created document. A question that came up at the last meeting: how do we know that the work product that's submitted is that of the supervisee and not the result of an iterative process, significant review and revision by others? As I understand it, and based on conversations that I had with Professor Merritt, Oregon is having them submit the first drafts, right? Before they go through the iterative process. They're all redacted. They're conflict check processes, even though they're redacted, to ensure that, the regulator who's grading it isn't on the other side of the litigation that persuasive memo is about. And then they also, and to the extent that the work product uses some existing templates, the reflections of the participant and the rubrics that the supervisor provides are asked about that, so the regulator can fully understand the extent of original work, because that is critical, as we talked about, the need to assess how this person is performing and not how others in the organization that they are being supervised by perform. So that, again, models of ways to assess these. I think it was helpful for me to wrap my arms around looking at the Oregon rubrics and how they do this, sort of to understand the types of things that we could be requesting based on the CAPA knowledge, skills, and abilities, right? These are the things that we think demonstrate minimum competence. So we would want to make sure that that knowledge, skills, and abilities, that the knowledge and those skills and abilities are reflected in the work that is performed. There were two other items that your discussions at the last several meetings have revolved around that I wanted to discuss briefly before we open the issue up, this full issue up to general discussion. And that is equity and access to supervisors and treatment of supervisees. So starting with the treatment of supervisees, that is wanting to ensure that they're not being taken advantage of, among other things. The Oregon Provisional Licensure Program provides another example that we can look to. The program requires that the employer provide a minimum number of hours that the provisional licensee would participate in, and a minimum level of compensation that would be provided. It requires the employers to make a good faith commitment to continue that employment while the provisional licensee remains in the program. Again, these are just examples. But I think, the issue of ensuring that supervisees or participants are not being taken advantage of is one that I think we all agree we need to be aware of, and we need to make affirmative choices in any program design, such as a choice to require compensation, for example. We need to make those affirmative choices to address that treatment. Right, it's a challenging issue, but there are ways to try and address it, to try and limit, some of the things that we've read about, like in the Ontario program, where the supervisees were feeling like they were not being well treated and were being taken advantage of. Oregon also has a new lawyer mentorship program for all new lawyers, not just for their provisional licensure program. But I also found that instructive. As part of that program, the participant and the mentor are required to discuss things like cultural competence, professionalism, dealing with challenging relationships, warning signs of substance abuse and depression. I doubt that California has the resources to build such a mentorship program, but we can build training programs that are required for the supervisor and for the participants, to include those kind of topics, as well as topics about DEI, implicit bias, and other topics that we would require the supervisor and the supervisee to take and to help protect against inappropriate or unacceptable treatment or working conditions for the supervisee. Again, just some options that may exist out there to identify that there are ways to address these problems that we are concerned about, not to provide a particular solution necessarily right now. The final issue that I mentioned was the equity and access to supervisors. And I just wanted to talk briefly about one approach that staff have been batting around, and that's use of a matching program. I've seen matching programs in medical and veterinary residency and fellowship programs in particular, and they provided just a concept that we thought was worthy of exploring. And so with regard to at least the programs that I've looked at, we've got an intermediary that runs the matching program, in which applicants that are interested in getting paired up with a program and programs looking for applicants or participants, they enter their information into the system. The organizations or programs, however you'd like to describe them, are obviously allowed to set their requirements for eligibility, right? We do criminal defense. I need somebody who has criminal defense background. I'm not interested in somebody who is particularly interested in family law, right? So you can set those eligibility requirements. Obviously, the programs can interview applicants that are interested in their program. And then at the end of the day, applicants and the programs respectively rank their choices in one of several fashions, depending on the particular program. And then they are matched together. The programs that I've looked at so far are voluntary participation, but I would think that they don't have to be, and that may make sense when you're talking, national programs. But if we're talking about, a program specific to California, potentially an alternative pathway could require those who are interested in taking on a participant and potential supervisees to require them to submit their information into the system. Supervisors would have to agree to such things as training by the regulator, providing minimum compensation, for example, performing the assessments that are required by the program, et cetera. Each organization and applicant could have to be admitted into the program based on meeting defined eligibility requirements and agreeing to program rules. Program rules could include things that are intended to reduce disparate treatment by demographic characteristic or law school type. I don't know, maybe such as prohibiting the disclosure of the law school until at least a certain point in the matching process. We might envision that there are 3 separate matching programs depending on sector, or one program with three branches, right? Applicants wanting a position in nonprofit would apply for nonprofit and matched against nonprofit programs that are looking for participants. And there'd be a different application if you're seeking to be matched with a private firm or government, et cetera. Again, I don't think it's necessary at this time, or probably even a good use of the commission's time to debate the aspects of what you would want to see in a matching program. But I bring this up to demonstrate that there are methods that we can use to increase equity in access to supervisors, because this has been, I think, a concern that we've expressed from the very first meeting that we had, wanting to make sure that if we are providing this pathway, that there is equal access to it. And we are not creating a limit on who can really participate, because only certain people will have access to supervisors. With that, Josh, I have finished what I was prepared to say, so I turn it back to you.
Okay, great. Thanks, Donna. Thanks, Audrey, for some of the background. What I'd like to do is just do just a really quick kind of little more detailed review than I did in the chair remarks, and then turn it over for discussion. I think we've had almost 2 months now since our last meeting, and I'm curious on some folks' thoughts and road forward. Without pulling them up, but giving just a quick summary for those that were there, and then a few new faces that were not with us on August 16th. Not new, but not with us on August 16th. We had a motion on the floor that had been seconded and we voted on, that was to explore a non-exam pathway. It laid out some requirements around law school supervised practice and assessment. We voted on that, and it was narrowly defeated. It was a pretty split vote. We then turned to a motion that was to completely forego an alternative pathway, and that was moved to the floor and seconded, and that was voted on, and also was narrowly defeated. And so we left that meeting with the, I think, understanding and desire that there may be a middle ground between them. I know that I believe it was Karen Silverman, but I apologize if I'm not correct. Somebody had circulated another motion as a possibility to be considered. And so we do have some alternative thoughts and motions, but before we go there, I wanted to just open the floor up and hear from the members of this commission on thoughts they've had since that meeting, and ways that we can kind of bridge the gap. I think everybody understands that we are not in a position today to make a full recommendation with details, but I do think there are some folks that believe in exploration with certain parameters is still a possibility. So with that, is there anybody that would like to begin? I'm going to give you guys another minute to think about it. Yeah, Judge.
Well, I didn't plan on going first, but
Appreciate it.
so I apologize for missing the last meeting. There are a multitude of Californians, I think in the many, many thousands, perhaps tens of thousands, who would be fabulous attorneys who would well serve our underrepresented and underserved communities, who don't perform well on an all stakes, high pressure, 2-day, all or nothing, if you will, make or break exam. And why is that? Some people have panic or anxiety attacks when they've put so many years of their life on hold for themselves and their families to pursue this avocation. There are people who need other formats in which to demonstrate their proficiency. There are people who have different cultural backgrounds who aren't accustomed to what we have grown up with as our testing format. About a month ago, I was in a mediation as neutral, and a lawyer there told me the story about a court, which shall remain nameless, that he went into. There was no court reporter, and the lawyers were in the courtroom simply to get a continuance. And this particular lawyer wore a yarmulke into the courtroom, and the judge asked to continue the case to a date certain. And the judge said, it's going to be October, whatever. And the lawyer says, well, Judge, that's Rosh Hashanah. That's a important religious holiday for me. Can we please do it on any other day than that? And the judge, without skipping a beat, told the lawyer, you should have thought of that before you entered this profession, and set the hearing for that religious holiday. And so to analogize that, because I immediately thought about this committee when I heard that story, we have people who, as I noted, take time, years away from their families, in many occasions, invest hundreds of thousands of dollars, train to be counsel, to be a lawyer, but it turns out they don't perform well on 2-day, high stakes, all pressure exams. And so I've listened very carefully at these meetings. There are professional psychometricians in the room. They advise that a supervised practice pathway, using Donna's term, using the right rubrics, can be properly designed, devised, and satisfactorily assessed to assure compliance. And so for all those thousands of people, I get it. Many take the bar exam over and over again for years and ultimately become an attorney. What does the state get out of, making somebody study 8 times for an exam? I don't know. I'm not sure a lot, and I'm not sure the individual taking these exams 8 or 10 times benefits from those delays either. But closing the door to those folks who don't perform well on the all stakes 2-day, in my day, 3-day high stakes exam, telling them basically, you should have thought about that before you went to law school, doesn't sit well with me. And so I think we should open our minds to other options for all those people for whom there's a better suited fit to gauge their competence. Thank you.
Kristen?
Thanks. I am actually, I'm going to say one of those people that Judge Reeser was just talking about, where I am trying to open my mind. I am here as one of 2 members from the State Bar's Council on Access and Fairness. And one of the primary things that COAF spends so much time on is this pipeline, diversifying the pipeline to the legal profession. And so to the extent that a traditional bar exam impedes the ability to diversify the profession, we are of course concerned. But COAF also has some of the concerns that Donna raised. And one of those has to do with the equity in getting supervisors for sure, but realistically, this isn't a program that we can offer to everyone, at least not out of the gate. And so for COAF, there's a concern about who's going to get to use an alternative pathway and the equity issues involved in who gets to use that path, and how we're going to decide who uses that path. And then there's the issues that come into play about supervisors and who gets the supervisors, and maybe a matching program is the right idea. But from what we can see in the Canadian report, we have to have a mechanism to address discrimination within that supervisory system. And then there's the idea of this alternative pathway and the stigma that could be attached to the alternative pathway if it is seen as a lesser than. And what I mean by that is the conception by some folks, and it's there because we've all read the public comments together. This idea that an alternative pathway is a way for folks who could not pass the bar exam, who may not be able to meet the minimum competencies, to become attorneys. And from COA's perspective, that's troubling, because if in fact we are offering this program, this non-exam pathway, as a means of helping to diversify the profession and opening it up to the non-traditional law students, that we want to help diversify the profession, that using that pathway is actually going to make it harder for them to succeed in the profession, because people are going to look at it and say, well, you didn't have to pass the bar exam, you came into this a different way. And those sort of elements of bias entering in, I think, have to be addressed before we can adopt a non-exam pathway. And so I do think, and I apologize, much like Judge Reeser, I missed the August meeting, but I read the motions and the minutes, and I think that maybe there is a middle ground here. But I think that the middle ground requires us to do a lot more work, and maybe it's beyond the scope of this commission. But I think that there has to be research done, whether it's by this commission or somebody else, on how we address those elements of equity and access and bias in a non-exam pathway, so that we're not creating a pathway that ends up making it more difficult for those folks who used it to be folded into the profession. So with that, I see my fellow COAF member, Ryan Harrison, has his hand up as well, but Josh, I will cede the floor. Thank you.
Kristen, I want, right before Ryan speaks, I want to repeat something from the last meeting. I think that we all agree and understand how difficult it is, and that there's nothing easy about this. I think where we left off last time is, are we willing to make a recommendation for to the Board of Trustees and to the California Supreme Court that this is worth the hard work and the exploration, and knowing that we can put in all of the language around our concerns, especially with equity and inclusion, which we tried to do last time? Or are we saying that for whatever reason, because of difficulty or otherwise, that this just isn't a direction that we should spend any time, and make a recommendation that we believe that the path of changes to the exam that we've already discussed in prior meetings is enough to get us to where we want to go in the future? With that, Ryan.
Thank you, Joshua. So I want to fully adopt everything Judge Christian said, but I wanted to add another component, because I keep hearing this rationale that some folks just can't perform well on an exam. Maybe they freeze up because of the stress of it all, or something to that effect. And I just wanted to note that being a lawyer generally is a very high stakes. You find yourself in high stakes situation where things are on the line and you have to perform. You have to perform for your client. And that's in the transactional sense, that's in the litigation sense, sometimes even in the policy sense, where you're briefing someone like the governor or a senator or an assembly member on law, and everyone's looking at you and you've got to perform, something like that. I think we need to be mindful that the bar exam is a stress test. Yes, we're looking at changing it and doing things around the bar exam, but to the extent that the argument is that we should offer this non-exam pathway because some people cannot perform well under stress, we need to be cautious of that. We need to really not even, I think, appreciate that rationale, because remember, people's lives are in our hands as attorneys, their businesses, their personal financial situation, everything, the freedom. And we need to make sure that people who are given the license to practice law in the state of California can perform under stress. So I wanted to add that as well. Thank you.
Tracy?
Good morning. In addition to my current role as the Department of Consumer Affairs, I've had the honor of being the interim executive officer at the Dental Board of California for the past 2 months. And they have what's called a portfolio pathway for the dentist. And I can share with you that it has not been operating as intended. The goal was to create a non-exam pathway for dentists, something different and new, demonstrate their abilities, their knowledge, skills, and abilities through a different pathway. And we have found it's not being utilized. And although there was great expectation, it appears that it is extremely cumbersome. The challenges with recruiting raters, subject matter experts, to make sure that it's standardized and consistent has been very, as I said, cumbersome. And it's much easier for the students, the applicants, to take an examination, whether it's the state exam in the past, or recently there's regional and national exams. So this profession does have the option of taking national exams, but due to transportability and various factors, in the current environment, portfolio isn't working. And so, the board is looking at ways to possibly make it less cumbersome, but it is very complex. And I do have to say that, you can always put effort forth to create, alternatives and options. But I firmly believe that when you're talking about attorneys, it is high stakes, and that there needs to be an objective tool such as an exam to evaluate candidates. And I personally feel that that's where the effort needs to go, is to modify the current exam before any other alternatives are explored. Having worked, on the exams in various capacities or exams, they are very complex, and I'm not convinced that they need to be that complex in order to make competency decisions. I think there's a number of strategies that can be taken to have a fair, valid, and legally defensible exam, and do it in a way that it addresses the concerns that have been raised to support a non-exam pathway. Again, in my professional opinion, many of these alternatives and options that are discussed regarding the non-exam pathway are things that I think would be great for programs, for students to experience in their educational program, not as a high stakes test for entering into a very stressful, intense, and high stakes profession where the consequences to clients is very significant. Thank you.
Karen?
Thank you. I'll be brief and would certainly echo +1 many of the comments that have been made. I guess I am still of the mind that a lot of what we are hearing about the purpose of a non-exam pathway is to address problems that we're not sure will be problems if we are able to implement some of the modifications and improvements to a new exam, and that we need to have some understanding of what we think the residual challenges are going to be once that new exam format, content, and intention is sort of more fully developed. So not much has changed in my view. I'm still in the never say never camp, but I think we're not necessarily sure about what problem we're solving when we talk about the non-exam pathway, and that to the extent that there are residual access issues or performance issues, that those could be addressed in some more targeted way, perhaps, once we've got a clearer sense of who's impacted and how that is playing itself out, rather than taking on this extremely complicated, perhaps not, efficacious second path that could lead to these sort of tiered admissions and I think some unintended consequences that will not benefit the population we're trying to support.
Karen, as the chair, I feel a duty to work in the direction that the majority wants to go, and I'm going to work really hard to get wherever that is. I will say, from a personal standpoint, I shared this with this group, and I shared it on the. You could see it with my votes last time. My concern with the sentiment you expressed is that the exam is so far away in it being changed and implemented, and us gathering information on it. And so I do have some concern of closing off an exploration completely, in that by the time we look up 3, 4, 5+ years from now and say, oh geez, maybe we should have thought about it, we will have not done any work towards it. And so I don't know that it'll be implemented or not, but that's been my concern. I agree that it would be great to have the changes to the exam. It'd be great to know, what the effect is, but we don't have that luxury, and that's one of my issues.
Yeah, could we design them? I'm not sure we would need to delay the exploration entirely, but I think we could design. We could go about the new exam design with it in mind to understand how it's resolving or not resolving these issues, so that it's essentially done in parallel. I mean, I see the point, but I mean, and I'm, I guess, also curious what the delay in getting a non-exam pathway together would be, because it sounds really complicated, right? Like there's still a lot of things we would have to do to get that up and running as well, perhaps more quickly than a revised exam. But I still have a lot of, I think these are very, I think they need to be complementary, I guess is my point. And at this point, it's not clear to me that we're talking about them in that way.
Leah, you have some comments?
Yeah, I just wonder if we've done a disservice to the conversation by framing the non-exam pathway as easier or helping increase access for folks who can't pass the bar exam. I think if we've done that, it's been a mistake, because certainly that's not my view of the sort of different alternative licensing pathway. I don't think there's any evidence that a test-based pathway produces more competent lawyers than a practice-based pathway. And I think sort of inherently intuitive is the idea that if you actually work under someone who is licensed and is competent and they are training you, you are going to have more practical skills and ability than if you simply sit for an exam. So I think that we're kind of thinking about this in incorrect fashion. I have looked at data out of Canada, for example. They have lower complaint rates against their attorneys than we do here in California, lower rates of discipline. There you have, a living, breathing model of experiential based licensing. So I guess I would just throw that out there, that we seem to be coming from this with the idea that the test, just because we've always done it that way, that somehow that is the best way to do it. And this alternative is a lesser than that we're going to try to cobble together to help folks who can't make it through the test pathway. And I just would encourage us, and including staff, like I think we have to be careful about how we frame it. So I think I'll just pause there. And just in terms of the new exam, I think we're at least 5 to 7 years out on the exam, in part because of a statutory requirement that we provide law schools with, I believe, 2 years of notice before any substantive change to the bar exam. So we're many years away. I do not think necessarily we would be that many years away on a non-exam pathway, which I imagine we would begin in a small fashion, sort of a limited rollout pilot, and build upon what is in play, has been put in place for the PLL. So I'll pause there. Thanks.
Thank you. Jackie?
Yeah, thank you. And I appreciate Leah's comments. I wanted to start with that as well, which is when I talked about this in the subcommittee on the non-exam pathway, it was very much about how law schools could transform their curriculums to better prepare students for the actual practice of law, rather than for a high stakes 2-day exam that really doesn't reflect in real ways what they're going to be doing when they get out there. And I think any of us who have taken the bar exam in practice will speak to the idea that preparing for the bar exam had very little to do with what we are actually tasked with doing when we entered our firm or our government agency or not-for-profit. So I don't think that there's a disagreement about that part of it. And so I do want to reframe this as asking the question, is there an equal or even better alternative to a high-stakes two-day exam to prepare people to enter the practice of law? And I think what we have before us is other professions who go about and do use practice-based assessment as part of their licensing. We've got other jurisdictions who are doing it here in the United States. We have other countries who do it. It's showing that it can work. We have a lot to figure out about how to make it effective here in California, but I do want to remind people that Proposal A is written simply to recommend that we explore a non-exam pathway to licensure. And that was because people were uncomfortable with a straight up recommendation of going forward with a non-exam pathway. So the proposal was changed to have the Blue Ribbon Commission recommend the exploration of it. And so if we vote no, that means there'll be no exploration, no chance to figure out whether we can develop an objective assessment, no way to figure out whether we can explore solutions to the issues that have been raised here. And there's no ability to pilot or test it to figure out whether or not we can do it well, and whether or not it actually does result in equal, if not better prepared young attorneys or new attorneys in the profession. So I just feel strongly that closing the door on even exploration is, even though everything people have identified are important things that need to be addressed in that exploration, is just shutting the door on really what the future is. And I would recommend that we at least allow the state of California to move forward with exploration of a non-exam pathway.
Thank you. Emily?
So I voted no on both motions last time, one to not move the proposed A forward, and then also to not completely stop this conversation. And since then, I have reflected on a couple things. One is that my issues with the motion, the proposed A motion last time, related to how we, the piece on assessment and oversight of the supervised practice, and how we were going to make sure that minimum competency was assessed properly. And then also, I've been thinking about the supervision piece and looking at Ontario and how little supervision Ontario really has over their articling, or actually Canada has over their articling program. It just seems like there's not as much oversight. So I guess where I am now with this is that I would be prepared to move forward and vote for us continuing to explore this non-exam pathway. But I will say that I like the idea of Ontario's examination that they have that's required for everybody. That's an online open book exam that we could actually just have, you know, the 8 CAPA subject matter subjects tested as part of this process. I would also say for me that the supervised practice, you know, in conjunction with, I guess this is really option 3 that we looked at, but the California prep program. So having the state bar establish a California prep program that would be this like combination of the modules, the in-person workshops, all the things that go along with supervised practice, but also really monitoring the supervised practice. So if we do have access and discrimination issues, those are brought up, that the state bar there's a way to make sure that those things are being monitored. And so I will say the biggest reason though, I would really like to see public comment on this. I would like to get us to the point where we are saying, you know, we would like to explore a non-exam pathway, and here's some components that we're thinking about. I don't want to just say non-exam pathway and then public comments like go crazy. I'd like to say like, here's some components, like we, you know, 6 units in law school. We have a you know, a one-day exam that people still have to take on subject matter that's open book. We have, you know, 1,000 hours of supervised practice, and we have this, you know, California prep program course essentially that people need to take, or whatever they are. But I think moving that forward and at least getting us to the point of public comment where we are able to hear from the public, and maybe after that we come back and we say, after seeing all of this, we realize that there really is, this is not our focus right now, right? Because that is kind of my belief, is that our focus really should be on figuring out this exam. But I do think that there is an important piece to this that is not about access for those that can't pass the bar, but is actually about, as Jackie said, is there a better way to do this, right? I am convinced that there is a better way than a bar exam to do this. I just am, as I continue to vote, I'm not sure that we have what that is yet, but I don't want to stop that exploration. So that's kind of where I am. Thanks.
Yeah, that's a really important point we talked about last time. And for those that weren't with us, I want to just share kind of procedurally. So although our timeline is obviously being pushed just based on our ability to get to some decision making here, but we will have whatever our ultimate decision is will be written up in a report by State Bar staff. It will then be put out for public comment. We will have an opportunity as a commission to come back and review that public comment, to debate it, and then to move any recommendation to the Board of Trustees. So there is process still in this. And so Emily, thank you so much for reminding everybody and sharing that. Tracy?
Yes, I would just like to echo the comments that Emily made and Jackie as well. I do again think that supervised practice is great. I just don't necessarily see it as a separate pathway to an exam. I think it's something that should be included in the process. And I do think the exam should be shortened. There's no reason why there should be a 2-day test. And I continue to hear that the exam has little to do with practice. That is not what a licensing exam is supposed to do. You take an exam, you walk out and you go, yeah, that's what I studied. That's what I would expect to do at a general level. And also what's important to keep in mind is what we've found in our occupations. Those pathways that we would call qualify you for a licensing exam, that are like work only, we find that those individuals have a very deep knowledge of a very narrow focus. And those professions that have the educational pathway, those individuals have a very broad level of education. It's not very deep, but it covers a lot of areas. So when you think about these different pathways, you really need to think about expectations. Do you want them working in a supervised situation with a very narrow focus, and the expectation is if they get licensed, that's what they're going to do? Because usually once you're licensed, you can do anything, but yet you've tested them or they've gone through a very narrow pathway, whereas typically there's an expectation for them to have a very general body of knowledge and skill set. So they then go out and they, can choose where they want to be an expert at. So those are just some things to keep in mind. I think right now the current exam is trying to test everything, which is why it's very difficult. So that's something that has to be thought about. But again, I like the idea of supervised experience as part of the pathway. But again, the sort of end-all type of exam, whether it's open book, whether it's very general or very narrow, California specific, state, federal, that has to be figured out. The other thing that I don't understand, again, is why we're talking 5 to 7 years out. We do new exams all the time. We make changes. It doesn't take 5 to 7 years. Don't know the dynamics again with the state bar, but I would hope that once decisions are made, that the process can evolve more efficiently to get something in place to address these issues, why other pathways are explored or so forth. Thank you.
Before I go to Jeremy, Leah or Donna, do you guys want to talk just for a moment about the time frame around the changing of the exam? I mean, I think that's been discussed a couple of times, but it sounds like maybe some clarity would be helpful.
Yeah, I'll turn that over to you, Donna, because I think you're more familiar with the specifics than I am.
Well, that's an assumption. So I mean, I think there are things that we don't know, right? We have talked about exploring different exam designs. We've talked about exams with simulations. We've talked about computer-based assessments. We've talked about, is there a multiple choice? Is there not a multiple choice? Is it heavily performance test-based, et cetera? We're doing studies on open book versus closed book, extending the amount of time, right? So if somebody can better demonstrate their competence with an extra half hour, then shouldn't we just do that? So I think there are going to be a lot of components that go into designing the exam. Ultimately, right, and along with that, we need to develop the exam scope. Statutorily, what Leo was referring to before, statutorily, we have a requirement, an understandable requirement to give 2 years notice if we change the exam. We need to go back and look in terms of how much of that is about sort of knowing precisely what the exam looks like versus the scope of and the breadth of the content. But we do have that requirement to provide that notice so law schools can change their curriculum. I think, Tracy, this may in part go to your reaction to what you've heard others say, which about whether the bar exam is teaching what it's like to practice, what is expected in practice. Because to the extent that that is what the bar exam is teaching, then you would think that the scope, that the curriculum wouldn't need to change that much if we're just changing the design of the exam. If what we're looking to do, and what we are looking to do with an exam, is to make an exam that actually is about practice. And if law schools are now have their curriculum more geared, or some law schools more geared toward passing the exam, which is not a reflection, as we've heard some people say, of what it means to practice, then there will need to be that opportunity for law schools to change the curriculum and make sure students are properly prepared for that. So I think it goes to that fundamental question of whether law schools are teaching toward the exam and whether the exam is actually geared toward what it means to practice. And that fundamental potential disconnect is what's going to, I think, cause some lag time. I can't give you a precise prediction, but if we were to develop, and test and roll out 100 multiple choice questions, we're looking at an 18-month process for that. So if you add sort of other creative simulations or other ways to do it, I would expect that would take longer to develop that, and then the 2-year notice process.
It would seem, correct me if I'm wrong, because I'm just trying to be practical about it. If it was an 18-month process and 2 years to give notice, and then probably some period of time to get results and understand if there's any changes. So are we talking about maybe like a 3.5 to 4 year as the shortest time frame where we might be able to see the effect of the changes?
I just raised my hand. I wanted to jump in because the 18-month time frame, like for example, we've gotten a bid on that now for a current question we have about sort of replicating the status quo multiple choice portion of our exam. That's 18 months. So I think it's not realistic to believe it would be 18 months to do something more complex, even if by more complex, I mean very different from our status quo. To do something very different, I presume would take longer than 18 months. So I just wanted to put that out there about the 18 months.
Okay. Jeremy, you were next.
Thanks, Joshua. So I just want to, I'll point everybody back to the letter that CLA submitted. I think they sent out with the materials. So I won't go into much of the details there in terms of where I stand. I would still vote against the non-exam pathway. I agree with Ryan Harrison's comments and also Kristen's comments full-heartedly. Again, I think, you know, to me, it really just goes back to, you know, I think would like to see an exam, some form of exam. I thought maybe the commission might have been, you know, better served if we sort of would have had a combination activity where it was like you had some sort of apprenticeship program and then on top of that having some sort of exam. But I think at this point, where we're at, I think we need to address the current exam and taking into account some of the changes we want to see there, which is a big deal. And I also agree with Donna's points that getting into the point of what we're teaching law students and then whether that's reflected on the exam and then in turn whether it's reflected in what the practice of law is. I think that's like the most essential question going towards the exam. But again, I'm just firm in my position that I think we need to address the existing exam to test minimum competence. And I think there's a lot of things we can do in that regard. So thanks, Josh.
Great, thank you. Kristen.
Me again. I just wanted to, something that Tracy said, and I think Emily said as well, maybe the answer does lie in some sort of prep program, supervised practice, apprenticeship, and an exam. I mean, maybe that is where we can find common ground, because I feel like I want us to come to some consensus, and I feel like I do feel like an exam is perhaps right now not the best way, or at least this exam is not the best way, and maybe we can do it better, and that's what we're here for. But I also understand this idea of wanting practical experience. And again, I'm still mindful of the equity issue, which, is always in the forefront. But maybe we ought to consider a hybrid of some kind. Maybe that is where we can all meet. I don't know. My thought.
Dr. Henderson.
Thank you very much. I also, as all of us have, I'm sure, reflected since the last meeting on the right way to go forward. I feel a need to highlight a focus on the protection of consumers. That is the point of the bar exam. And just to remind everybody that the bar exam is a test, not a teaching tool. There have been a number of comments today that on the best way to prepare attorneys for what they need to know and be able to do in order to practice. Preparation is part of law school. The exam is assessment. It's assessment of readiness to practice, not preparation for it. So if the schools are focused on preparing people for the bar exam, instead of teaching people what they need to be really great attorneys, then I think that there's a misdirection in their focus. But having said that, I think, and I agree with what several folks have said so far. Supervised practice, to the degree that it's useful, it should be a function of the school, not of the admission to the bar. One of the advantages of a standardized bar exam is the breadth of content coverage that it's capable of putting into place. Supervised practice, by its very nature, is focused on a practice area or a practice setting. And but the license to practice law is permission to work broadly. And my fear is that that tight focus, that tight limitation in the assessment of readiness to practice is a disservice to the public. So I think supervised practice is a great thing, but its limitation is usually on the lack of breadth that it's able to offer. So I've got a suggestion for motion A at the time that it's appropriate to bring that up. But those are the things that I've been thinking about.
Okay, thank you. Wow, a lot to unpack in Dr. Henderson's comments, but I see I have two academics following, so we're going to go to Mylin.
I guess I'll pick up where Dr. Henderson's point that to the extent that law schools are preparing students and graduates for the bar exam, that's a problem. And Donna called it a disconnect. And of course, I can't speak on behalf of all schools, but I'm a full-time professor at UC Hastings, and I also have been teaching as a lecturer at UC Berkeley. I can tell you particularly with my home institution that is what I am doing in my doctrinal class. I came here, I cut short my evidence class. I've been teaching it for, 10 years. I teach to the test. I have eliminated every aspect, every practice point, every, I had a motion in limine exercise I used to do. I've eliminated all of the aspects of my course that were closely related to the practice of law, and I've replaced them with closed book, multiple choice, and bar style essay assessments. I think that's a huge problem. At the same, whatever the new bar exam is going to be, I'm going to teach to that. That's just the reality. And that is at a huge cost. I'd like to juxtapose that with what I do in my clinic, which is an in-house live client, live case employment law clinic where I teach my students to be lawyers. And we have to carve that time in those academic units out of the rest of their course load. And students are really, really torn about dedicating that many academic units to learning something that is not going to help them pass the bar on the first time. I think all of that to say, we have this validity issue where that is impacting everything all the way back to, and this goes to the timeline that the state bar folks are talking about. First day of orientation is already geared toward, here's what we're going to do to help you pass the bar. It is permeating our curriculum at huge cost. And I can't guarantee that the students who get A's in my evidence class, I know they're going to pass the bar, because it's a good predictor of that, but I don't know if they're going to be good lawyers. I have no idea. And last point is on the concept of high stakes that Ryan mentioned first and Jeremy picked up. I absolutely agree that lawyers have to be able to perform in a high stakes environment. I've practiced for 25 years now. All kinds of things are high stakes, but it's the client interview that's high stakes, or the oral argument that's high stakes.
it's not whether you can pick the right multiple choice answer while sitting in a chair for 6 hours, 2 days in a row. That's the high stakes environment that we're talking about. I think we have to have a better match between the high stakes of practice and the high stakes type of assessment that we're doing. And then the last thing that I want to, the last point is, I really hope that we don't close the door on a pilot program, some small attempt to start to build the information that we need in order to make this a pathway. I look forward to learning from the dentists through Tracy. I think we can do it. And I urge people not to let the perfect be the enemy of the better.
I am going to do this only because I'm chair and I have the ability to, and say, Mylin, that saddened me. I'm a Hastings alum. I remember evidence class and the changes that you've made. And I will tell you that the critical thinking that came with that class is something that I've always appreciated. So I'm sorry to hear those changes. Susan.
I'd like to actually back up a little bit and talk about something a little bit bigger picture. The thing that most deeply troubles me about most of our conversation today is that we're focused on the wrong thing. The Supreme Court has been extremely clear with what they asked us to do, and it was incredibly broad. They did not ask us to give a narrow recommendation to repair an extremely flawed exam. Instead, they asked us to consider things broadly, and our charge is about as broad as I've ever seen a public commission charged with. And I think it's important to recognize that we should be presenting the court with the best options. We should deliver more, not a minimum. We should say to the court, we have ideas about how to improve the examination, and we have ideas about how to offer an equal and at least equal, if not even better, non-exam pathway as an alternative to complement an examination alternative. I think that we have become focused somehow on that our narrow charge was to improve an exam, and it's not. So I'd like to start with the idea that a lot of the concerns that have been raised today are completely legitimate. I agree, being a lawyer is very stressful. I do not think that translates at all that we should have a stressful setting to determine your minimum competency. I think it's also important to consider things like the dental school, though we did not hear enough information to make comparisons about that today. I don't have any idea what their examination is like or what its pass rates are like, so it's not necessarily comparable to our professional examination. But we've also heard a lot of information from other jurisdictions and states and countries that would suggest we can do a non-exam pathway. We have also seen that supervision may present some issues. Perhaps we will need to be careful to craft it to be broad enough to address Dr. Henderson's concerns. Also, I think to address Judge Rosie's concerns about stigma, we need to be careful to craft it in a way that it does not become a secondary option. But I think it's important to recognize that overall, none of these concerns say we should not be exploring a non-exam pathway. They merely suggest that it may not be a simple path, that it may be a path that will require a lot of public comment, a lot of implementation, but that is a future commission, not ours. Our commission was asked by the Supreme Court to consider broadly, to address broadly, and if we want to find common ground, we can't be excluding the exploration of the new options that are out there and emerging in other jurisdictions. We risk leaving California behind. I've said it before, I continue to believe it. California needs to be a leader. And if we're going to be a leader, if we're going to find that hybrid, if we're going to find that good configuration of a non-exam pathway, the only way to do it is to vote in favor of exploration.
Charles?
Thank you, Chair. I will be brief. There was commentary made by Tracy Montez that really resonated with me that I would like to highlight. There was a discussion of the shift of focus on, or rather the effect of using a non-exam versus exam-based pathways to licensure, even outside of the law, specifically on the effect of encouraging depth of understanding versus breadth via an exam-based pathway. And that's something that I have experienced personally. I always try and couch my comments during this commission in what I believe to be the role of my seat, which is specifically to represent the, well, I'll say early stage attorneys who have been licensed. And I personally, during the process of this commission, have shifted fields of practice. I was a criminal defense trial attorney, and now I've shifted over to civil. And while I have absolutely nothing but positive things to say about my time practicing as a criminal defense attorney, I believe that my shift has fundamentally, for myself personally and professionally, been positive. However, that would not have been possible had I not had a generalist background in civil procedure and tort law that I believe is something that is encouraged by the current exam-based pathway. And because of that, I think there is true value to the generalist approach to legal education, to creating attorneys who are, when they're licensed, generalists. And flowing from that, I think a lot of credit that goes to the provisional license program that is currently underway is in part due to the fact that the cohort that has gone through it and is working through, is operating under that approval, were trained as generalists. The program, essentially from where I stand, was instituted because of COVID, but that wasn't anticipated. The individuals who are currently participating in the program were undergoing a curriculum of education that anticipated the bar exam at the end. And I would say that the success of that program is itself in some ways indicative of the benefits of training generalists to be capable of practicing in a broad area across fields upon their entry into what is still fundamentally a market. And with that said, I will cede my time to the chair.
Thank you. Natalie.
I want to just start by saying I'm a little discouraged by some of what I perceive as an all or nothing tone to this conversation. I don't think we are being asked to decide, is one pathway better than the other? It was simply, can there be alternative paths to licensure, one of them being a bar examination, which I feel like we've already addressed. I'd also like to think that the CAPA recommendations are not only for the bar exam that we are going to be creating, but that we can take what we've learned from CAPA and import that great information into this alternative pathway that has nothing to do with a bar examination. So I think we can still assess in an alternative pathway whether applicants are capable of being generalists. I can't imagine that a law school would stop teaching some of these fundamental core subjects anyhow, even if there was no bar exam, because that goes into being a good lawyer, which is, I think, what we're focusing on, right? What is it that a new attorney needs to be able to do to be a capable, proficient, do good for the public kind of attorney? I don't think that there is only one way to do that. Clearly, Oregon has been able to figure it out. And I'd go back to what Susan has said. What was the charge for this group? It was not to design the perfect assessment, whether it's the bar examination or an alternative pathway. It was simply, can there be another way of doing it better than we have been doing it? And what vehicle we use and come up with that is for another group. And I would hope that it's a group that's filled with way more folks that are good at creating assessments and making sure that they're valid and reliable. I absolutely believe that's important. And I am so grateful for the folks that we have in this group that have been able to give us that information and that background. And but I do still think, I believe that there is a way to do that that does not require a bar exam, that can be 100% just as valid, just as reliable. Thank you.
Okay, what I'd like to do now is take a break, a lunch break for 15 to 20 minutes, and then we're going to come back and we're going to open the floor up to motions. I think we received all the information over many months we've been at this, at different programs, what the possibilities are. I think people have their opinions at this point, and I think it's time for us to figure out whether or not we have a consensus of any kind for a recommendation. So Audrey, if we can, let's break now. Let's come back at 12:15 and then we'll get back to work.
Sounds good. Thank you.
You. All right, folks, we'll just wait another minute, let some more people come back. Devin, will you remind me, do we need to take roll after a break?
We do not.
Okay, great. Okay, let's get back into it. So couple of things. One, I want to make clear, we are going to spend as much time as we need to until 2 p.m. I know I went over a little bit last time, not going to let that happen. Wherever we are at 2 p.m. today, we will break on the nose for everyone's schedule. If we're able to get through this first issue, we will move to the next item of business. And Amy Nunez is here to report on some recommendations for us. So where I'd like to start is, I think I'd like to ask if there are any motions to be brought forward. From there, I think we can start a conversation and see where we can go. I think people understand that we have looked at this issue and have specific items that have some concern, and so hopefully we'll figure out where a middle ground is, if that's at all possible. Yes, Emily.
Thanks, Chair. So the motion that I'm putting forth, I can share my screen and show you, but I'm trying to do a middle ground with kind of what we talked about, incorporating an examination and some oversight. So I will just, if it's okay, share my screen.
Yep, that's fine. You can do that. If you don't mind, they're pretty complex at this point. If you could just start at the top and just walk everyone through it, and then we can have a discussion about it.
Sounds good. So the first part, first paragraph doesn't change anything from what we see in the proposed motion A. It's really the preamble, which says we'd like to explore a bar exam alternative, and also recommending that exploration, have a significantly increased focus on knowledge, skills, and abilities rather than memorization. And then the also having, making sure that whatever we're doing when we do this, that we're consulting with the psychometricians, experts, to ensure that it is as valid and reliable an assessment as a bar exam. And that may be a tall order, but if that's the committee's recommendation, like, look, we're not going to do a non-exam pathway unless it is as reliable as we would, the equivalent reliability to a bar exam, then that maybe not be something that we can do, but I don't think that's too lofty a goal. So to put some meat around the bones, one of so this is the next piece of this. There will be the law school component, which we've already talked about in options 1 and 3, which is the 6 units of experiential education, but making that modified so that the CAPA requirements specifically have to be achieved in the courses that are being taken for that. The second piece would be an examination, and it would be online, open book, and it would test the knowledge of the subject matter topics in CAPA. The Ontario folks use just multiple choice. I don't know that we want to do that, but I do think that this examination piece could be something that is looked at, that anybody that is doing this pathway still has to pass this examination. So that would be piece number 2, and just one of the 2 components of assessment. Then after graduation, there would be a supervised practice. I have a minimum hours here of 1,120, and that is because that is about 28 weeks. If you go full time, allowing also for like a 2-week break in there. So that would be hard to do, but if somebody did it full time, it would be roughly July 1 to the end of the year. But probably that's going to take longer. So that would be one option. And the other option too, obviously, is to have, less specificity as to hours, but I know we've been talking about that. And then the fourth piece is what we were talking about before, which is kind of this California Practice Readiness Education Program. It's both an education program and also an assessment. So they have to, just as they do in Ontario, they have to go through each of these modules, scoring on them. As Donna talked about, the different levels of whether or not they are like almost meeting competence, whether they are meeting competence, exceeding competence. Those are the things that we would have throughout essentially this 6 months supervised practice. The non-exam pathway would also have this program that they're all enrolled in. And so it's also assessments along the way. So it's a little bit different than what the Canada model is. I think it actually might have more assessments built in. And then the capstone at the end, where they have to turn in all of the things they've done essentially at the supervised practice period. And then this would also allow, this program would also allow for check-in or monitoring-ish by the state bar, but check-in allowing the participants, if there is an issue or some problem with their supervisor, making sure that there is somebody to tell, right? That we have not seen that in Canada. We don't have necessarily they don't have a good feedback loop. And I think that's one of the problems that they're having and why they're seeing so many problems is there's not some regulators sort of stepping in on that. And then the last piece is just to obviously ensure that all the rest of the licensing requirements are in place, just as if you were taking a bar exam. So I'll stop there. This is, can be wordsmithed or not, but I'm happy to answer questions or leave it as it is.
Well, let's start with any questions or clarifications on this language. Susan?
I'm not sure how you want to proceed procedurally, Josh, if you want me to actually move to amend it, or if you just want me to address some concerns I have with the language.
Yeah, let's start with the concerns and kind of work through them. And then if we get to the point where we get a second, then we'll look to amend it.
Let me give you a couple big picture ideas. The first big picture concept is the proposal initially starts by saying this isn't exploration. But then the very last line of the opening paragraph there says that the pathway shall include these items. That's not a recommendation to explore. That is implementation of one particular pathway that does these things. So I think we would need to change that language instead of shall include to be shall evaluate or explore or whatever it is we want to do to make the language consistent with the opening line that says we should explore an alternative to licensure. Because I don't believe that our intention is to recommend a single particular path. Along those same lines, I think that the concepts here are good ones and ones we've seen and discussed, but I would make them more generic. For example, the post-graduation, I don't think it should set a set number of hours. We should go to the range that we've been using that came from a variety of approaches, which I believe was 750 to 1500. I also think we want to avoid sort of the, I like the CAPA recommendation because that's very generic and fits nicely with exploration. The prep component here, I think is far too specific. I think we should just consider a prep-like program. I don't think we should be saying exactly what it may or may not include. We did not look at anything except one. That seems, again, to me to be implementation, not exploration. So I would remove implementation details. I would put in generic components only for things to consider. And I would strike the last bullet point altogether as unnecessary and beyond the scope of the commission's charge. We're not addressing that in any other capacity. I don't think we should address it in this capacity either. I think it's a given that, of course, it would do those things.
Okay, thank you for your comments. Dr. Henderson?
Thank you. I just have a suggestion about language in the first paragraph, where it says that It was hidden, so I have to find it again. Sorry. Okay, in the about 8th line that begins with the word psychometricians, the phrase "to ensure the pathway is valid and reliable," I would suggest "to ensure data about the pathway indicate it is." Thank you.
Emily, when you thought about this, the one piece that I see that we've talked about that either was not incorporated because you thought it wasn't necessary was scope and size of the program. When you thought about this, how did you do you think it was worth being part of the recommendation? I think some people believe that the only way this can work is if you start small and understand it and build to it. What did you think on that topic?
Yeah, I think that's a good, I don't necessarily have a definitive answer, but, and maybe it's naive of me. I don't think that we're going to have a flock of people to this, but I do think eventually we might. So I think the pilot program idea, just even that phrase, and then somebody, not me, can figure out what that looks like, but maybe the recommendation being a pilot program.
We'll see where this goes. Mylin, thoughts?
I would maybe change in the third bullet point. I personally would I would not want to limit the supervised practice to post-graduation. I think it may well be more efficient and more overall better to have some of the supervised practice be allowed during law school, either within law school. So for example, I'm not sure that, to me, it seems like if somebody's in my clinic, if that could count toward their supervised practice hours, that would be very beneficial for everybody because they're getting, if I may say, pretty good supervision. And also I wonder whether summers ought to count. So I can't remember where we landed on that. I know we've discussed it in the past, but preventing pre-graduation supervised practice is not something that I would recommend. So I'd like to leave that door open for now.
So
I think this should probably be titled that anyway. So I'm regardless of whether it's post, I think post-graduation doesn't need to be the title of that, but we can figure out.
So that is clearly there is a divide in conversations we've had in the past around this practice and where it begins. And so I want to be a little careful. We can obviously get a friendly amendment and see if we can get there. And if that's the direction people have, but I do think that's an issue that's a substantive issue that we've had some disagreement on this commission about. Donna, you looked like you had a question or comment.
Well, I was going to raise something, but I worry it's going to take us down a rabbit hole that we don't need to go down right now. So
okay,
I'm gonna stay quiet.
there is it's not seeing any other questions at this point. Let's go to Jackie before we go there. Jackie.
Sorry about that. I just had a question, Emily, and thank you for bringing forth something that hopefully people feel comfortable with. Again, focused on the idea of assessing whether someone is competent to practice law. We have on the one hand a bar examination at the time that they get a score, they're deemed competent if that score equals a certain amount. Here we've got an examination, supervised practice, and potentially a prep program with objective assessments. I'm wondering why, if we were going to require new attorneys to do a prep program, why we wouldn't require all new attorneys to establish that they have kind of that basic practical experience and knowledge that you need to hang a shingle out on your own rather than just the bar exam? Why would this be limited to an alternative pathway?
I mean, I'm just responding for myself. Obviously, we can debate this. I don't see that it is that is necessarily up for discussion because our exam pathway doesn't include that. I will also say I don't disagree with this assessment that you've just made. I do think though with a pilot program, we have to see if this actually is something that would work. And then if it works, then we've looked at it, we may say, State Bar may say, everybody should be doing this, right? But I just don't know that we can say that yet. I don't know that that would be a requirement for everybody at this point, or that that's really within our scope. And Josh, we don't need to belabor this. I'm sure there's other people with motions, and if there's not a second, that's fine. But I am also happy to keep it up and keep sharing my screen if it's helpful.
Well, let's move from this and see where we go. I want to be clear. There is no a clean way to go through this process. I mean, we have a lot of elements and a lot of different possibilities and machinations, and we have to start somewhere. And so I appreciate you bringing this forward, and I think it's a very good start, and we'll see how people feel about it. The changes that you just, Emily, can you put it back up? Do you mind just for 1 second?
Oh yeah.
The changes that you made to it, are those changes that you are willing to accept and would want to put it forward in this fashion?
Yes, I mean, I don't think anything seems too controversial to me. The one piece is what Mylin brought in, which is the supervised practice, which I'm not at this point prepared to necessarily lose the, well, I've taken out post-graduation, but I haven't put in what it's going to be. And so I'm not really sure about that yet. I'm not a big fan of it. I'm a fan of a clean break, but I can also see the point of maybe like 3L, 3Ls having some of that practice. Anyway, so I'm fine with it as it is now.
Can you make two language just corrections in under practice readiness? It should be possibly including, instead of possibly with. And then I think you would need to strike the 11-20 hours if your intention is to have 750 to 15 range for
that one. I wasn't sure if I wanted to change, but I think for the sake of us, we should do that.
Yeah, that's okay. So what I'd like to do is let's hear from Mylin for a moment, and then I'll ask for a second. If there is one, we will attempt to move forward, and if not, we'll ask for alternative motions. Okay, Mylin.
I just want to make sure I understand what I might be voting on. Exploration of the following elements. So whatever the next step is, that body is free to eliminate any of these bullet points, expand on any of these bullet points. So this is not, I mean, it's sort of a menu for the next body to consider. I just want to make sure you're not saying this is, it must contain some variation on each one of these elements, right? This is I'm assuming we want this to be as broad as possible, which is why I offered the last edit.
I believe the goal is for it to be as broad as possible. The idea, obviously, that fits in with our mission. A couple of people have stated that at this meeting, and I do think that was a fair assessment of what we've been asked. It is to make a recommendation that will then be considered and given to another body to take it to the next step. So I don't believe that it's conclusive in any way, but I think we need to give our best recommendation of what we believe elements could look like.
And I think we're also saying, look, we're not interested in a diploma privilege, right? We're not interested in having the, sort of which I don't disagree with generally, but like the Deborah Merritt model of like everything's happening in law school, and we're not like, if you graduate from law school, you're good. So I think it is obviously we could just have the first paragraph and see where it goes, but I think that's kind of, I mean, again, at the end of the day, we might do that, but I think that we need to have something that we're sending to the Supreme Court to say, we think these are good things to focus on and to explore.
Okay, Dr. Henderson? You're still muted. Perfect.
Sorry about that.
Okay.
I guess, I can't see the entire first paragraph. But what I'm looking for is anything that is really standardized about this, and I'm not seeing it. I don't see anything around evaluating the level of proficiency that people demonstrate in their supervised practice, whether it's in the law school or not. So if it's in the law school, presumably they would have to pass the supervised practice in order to graduate. So I'm less concerned about that than I am about the third bullet on supervised practice. I see oversight and training, but I'm not seeing anything around a uniform standard of proficiency that would be applied. And so, that I think is an important element that needs to be built in. Unless I'm missing it, I can only see what's on the screen.
Yeah.
So maybe you add, Emily, something about a portfolio that is assessed by the regulator.
Yeah.
Under the third bullet point?
Yeah.
Okay.
I can send, there's no chat. I can send you the language that I had from those prior 3 options.
You can email me and I'll put it in.
Okay.
Or I can actually probably look at that option.
David?
I don't know, Josh, if this comment would be more appropriate if there were a second and we were debating, or whether I can say it now, but frankly, I consider the initial paragraph to be consistent with the concept of recommendation of exploration. And I consider the bullets to be inconsistent with that approach. And I would not be in a position to support the motion as framed. I would certainly be willing to consider supporting the first paragraph of the motion, as long as the language is clear that it is a recommendation. And I think the mere fact that we are discussing and debating the language of the bullets suggests to me that we are going beyond a recommendation of exploration. Thanks for letting me make that comment.
Yep, thank you for that comment. Emily, the one thing I think I'm going to call for a second, and then we can try some friendly amendments if we get one, and then we can kind of go from there. The one thing I will say that I think if somebody doesn't do it before me, I will add, is that I don't believe in this document, this would not send the message that we've discussed about the importance of equity and inclusion in any one of these recommendations. So I think we do need to build that in a little more. Okay, based on the language that Emily has and motion that she has in front of us, is there a second on this motion? Broken up a little bit. Was that, Judge, was that you?
Yes, I seconded the
Okay.
Emily's motion.
Roll call vote. Susan Boxian.
Based on the fact that we have a second on the floor, I would ask if there are any friendly amendments. Emily, I think I'm going to ask David to just restate his point as one and have that conversation for a second, and then we'll go to Susan.
So you're calling on me, Josh?
I am. Do you mind? Can you? Now we have a second. The motion's on the floor. It sounds like you have a friendly amendment. If you can just restate it for us, that would be great.
Yes, I would propose deleting the bullets entirely and delete including the preceding lead-in sentence, it is further recommended, and that we focus on the initial paragraph, and that and I think that solves most of my problems, although we probably should then reread carefully that opening paragraph to be sure that it is internally sound, given the deletion of the bullet points. And I haven't done that yet. So that would be my proposal.
Thank you. Emily, that was a request for a friendly amendment. How do you feel about that?
I don't disagree with it. So I'm kind of in a conundrum. I mean, I'd like to hear from Kristen and Susan, if that's okay. And then I think maybe that will help me.
Okay, Kristen?
Thanks. Actually, I was gonna, I think, echo a little bit of what David just said, and that is that the more we revise the bullet points, the less comfortable I become with it. And I think that if we just use the opening paragraph and we say we're going to explore it, then we're just going to explore it. And we don't, and I think the more we do, the more we specify what that exploration looks like, the more uncomfortable I get. And if we're going to go along that line, I think, you know, to Josh's point, there's nothing in there again about the equity aspect, and the equity aspect for me permeates the whole process. So I would, to the extent that we're not going to eliminate all the bullet points, and Emily doesn't want to do that, then I would, you know, ask for some language in there, maybe bringing back the equity piece from before.
And if somebody wants to send me what you want to add in the sentence or whatever it is on the equity piece, I mean, I can, there are definitely reasons for an alternative pathway, equitable equity and access reasons. There's other reasons as well. If we want to have a why statement, like why are we doing this? Why the recommendation? I don't know. I mean, that to me would be a whole other document. But if we want to just put something into this proposed recommendation that just talks about equity and access, I'm all for that.
Susan?
Josh, I'm not sure. Do you prefer that we up and down vote on this, or that we make the equity and access additional language and then proceed as this all one friendly amendment, or are we going to separate this into two? Because I agree with Emily, I don't think we need a why statement, and I think it's inappropriate. But I'm not particularly concerned about deleting the bullet points, because I do believe that the State Bar's complete report to the State Bar will include all of this information, and they will know the kinds of things we considered and debated and discussed. So we do not need to delineate those. I don't object to their deletion, but I think we could streamline the process by simply adding in one sentence at the end that says, the exploration will include consideration of the equity and access charge, and use some of the language from the chart. But I think we could put that in and do this as one rather than as two.
I think that is definitely a possibility. So I'm going to take one more comment from Jackie, and then Emily, we're going to need to move with whether or not you're going to accept a friendly amendment and how we move forward. Jackie.
Yeah, just when I'm looking at this and listening to the discussion and some of the concerns that are raised about what's included and not included, it seems that proposal A, which we voted on last week or 2 months ago, which includes the equity, disparity, and cost issues must be taken into account, and actually includes an assessment that could include a written exam component. I'm trying to figure out why we're recreating the wheel. Doesn't proposal A address many of the things that were raised in Emily? So Emily, I don't know whether you could help me understand what you're trying to achieve here that wasn't encompassed within proposal A.
Jackie,
Oh, go ahead.
Jackie, I think before Emily responds to that, I think what I am understanding and what I'm hearing, and I think David brought it up, is that each time we get into the elements, there seems to be more language that people are concerned with for whatever reason around each of these elements. And so when it's stripped to the concept, maybe is where I started to see a little bit of consensus, and that's obviously up to Emily, or we'll move to another motion. But every time we go into them, everybody has a little bit of a different view, and I think that's partially because we don't know.
Right, and that's why proposal A from 2 months ago was written very broadly, that didn't really spell out any particular part. So I was just trying to figure out how this proposal is different from that proposal.
I think this one really is more, with the bullet points, was more specific. I think without the bullet points, it's actually even less specific as it relates to assessment or any of the supervised practice. Like supervised practice itself would not be in this recommendation if the bullet points aren't there. It would just be, we're just still exploring a non-exam pathway.
And Emily, we're gonna need to move here. Is that something that you're willing to accept, that friendly amendment that David had?
Yes, I am. That doesn't stop anybody else from proposing something else with bullet points, but I think at this point, if we can do that, I'm still trying to write this last sentence, which I think is not going well, but yes, I will, for now, this proposed motion, I will just have it be this top paragraph.
You want me to read what was in the August 16th? It said, equity disparity and cost issues must be taken into account.
Okay. Equity disparity and
cost issues must be taken into account.
Is that okay?
I think it's probably cost, no S.
Yeah.
Or no S at the end.
Is there any other friendly amendments to this paragraph? Because now my motion, without a second, or no, I guess Rice, Judge Ricer, you need, or Reeser, you need to see if you still second.
I would, except in the last sentence, I would put considered as opposed to included, because I don't want this to be perceived as a second tier equity alternative, right?
Yeah.
Okay, Jeremy.
Thanks, Joshua. I would make the same friendly amendment that I attempted to last time, which was in the first sentence that this alternative pathway would not be pursued until after we have implemented a revised bar exam.
Sorry, Jeremy, I'm not accepting that one. But I have been there with you.
We're still friends, Emily. I still love you.
I know, I appreciate that. I've been there with you before because I actually liked that idea. I just think that we are so far from either of these right now that getting them both on getting even public comment would be a good thing. So that's where I am.
Okay, let me ask, are there any other amendments or comments to the motion, Emily's motion that's been seconded by the judge?
Josh, I just wanted to mention one thing.
Yep.
Very early on, the commission worked on a set of guiding principles, and some of those principles included exactly what was added here: equity, disparity, cost issues. I'm wondering if we should relate these back to the guiding principles, because one the other things that were in the guiding principles is, like, for example, the use of evidence-based practice in exploration would also be factored in here. So it's just an alternative method of getting to this is going back and adding the guiding principles into this motion. Just a suggestion.
Are you suggesting that we reference them?
Yes, or replace this. I have a I'll send this to Emily, but
Yeah, and I mean, this is up to Emily, not me at this point, but happy to look at them. I think there's good reason to leave in the specific equity disparity in cost consideration.
There's just one option if that's what you want to get at, Amy, but I'll look at your words.
okay. It's very similar to what you just added there.
Tracy?
I have a more simplified motion, and I don't know where that would fall into this. We just need to vote on this and then go to another one, but I'm just tossing that out, just some reduced verbiage. That's it. Thank you.
Okay. Tracy, is it, we can do that. Is there anything on this one that you believe that would make sense to suggest some verbiage changes that would be important to you? Or do you want to wait, vote on this, and then offer your alternative if that's the case?
Well, I like this one, but like I said, I've reduced it quite a bit. So I'd rather let the group vote and maybe go from there, see what folks think.
Okay. I think we made a change since the last second. So let's just ask Judge Reeser if he's still okay with this seconding this motion in its current form.
On behalf of the word police, in the last sentence, I would change the conjunction to conformity.
Okay. Any other comments, thoughts, friendly amendments? If not, let's go ahead and take a vote on this.
You want me to stop screen share or leave it up?
Nope, I think leaving it up is fine. You know what? Let's ask Devin what's easiest.
Yeah, you can leave it up. Roll call vote. Susan Bakshian,
Yes.
David Boyd,
Yes.
Alex Chan,
No.
Charles Dugan,
No.
Jeremy Evans,
No.
Jackie Gardina,
You're on mute.
Yes.
Ryan Harrison,
No.
Dr. Henderson,
Yes.
Esther Lynn,
No.
Tracy Montez,
No.
Judge Reeser,
Yes.
Natalie Rodriguez,
Yes.
Kristen Rossi,
No.
Emily Scavalletto,
Yes.
Karen Silverman,
No.
Nylon Spencer,
Yes.
Amy Williams.
Voting no.
The motion does not pass.
Okay. Open the floor to alternative motions. If anybody has a motion they'd like to offer. Tracy?
Thank you. How about the Blue Ribbon Commission recommends to the State Bar Board of Trustees and the
Tracy,
California.
Do you have the ability to share screen if you have a motion written, or share it with bar staff who can share screen?
Yes, let me.
You can.
If it's not too long, I'm typing as you are speaking, Tracy, and then I can
Okay.
share my screen and type.
Okay.
So long
It's
as
not
you
very
get
long.
far
Okay,
ahead of
let's
me.
try that.
Thank you.
Hang on, let me share my screen and I will type in front of everybody.
Okay, the Blue Ribbon Commission recommends to the State Bar Board of Trustees and the California Supreme Court that California
California what?
revise the current bar exam for licensure to competently practice law by addressing the guiding principles established by the Blue Ribbon Commission, period. Further, the Blue Ribbon Commission recommends to the State Bar Board of Trustees and the California Supreme Court to explore an alternative pathway that assesses the same knowledge, skills, and abilities of the revised bar exam to ensure protection of the public, period. And if you wanted to, pull out certain guiding principles and put them in there, you could do that. But I just said guiding principles for brevity. And I tried to capture everything that Emily did, just shrunk it a little bit, but I did distinguish between focusing on the revising the current exam with an exploration of an alternative pathway. I think that's just the difference I was trying to make. Thank you.
I'll take a second if there is one on Tracy's motion, or if there's any specific comments that someone wants to make. We're happy to listen to those first. I don't hear a second yet, so let me start with Susan.
Just a quick clarification. The phrase revised bar exam is undefined and I believe unclear, and we probably have 30 different definitions of what that means. I'm wondering if procedurally we don't need to coordinate this with the prior recommendation we already made on the examination, that this is somewhat inconsistent without either an express reference to it or an express incorporation of that language into this motion.
Can I get clarification on that? Because what I mean by revise, I mean by everything that we've talked about as a group, the various components of the exam pieces.
So if I may, Josh?
Yeah, please.
I think the point was that the commission has already adopted a motion specifying that we adopt a revised bar exam based on the CAPA knowledge, skills, and abilities. So I think what I was hearing, I'm sorry, my memory is already going, Susan, I think, saying was that maybe deleting everything up through and including the further, and saying something like, in addition to the previously adopted recommendation about establishing a California specific bar exam, and then going into what's there. Should I try and capture that?
Tracy, is that consistent with what you were attempting to
Yes,
accomplish?
that's fine. Thank you.
Tracy, does that accomplish it?
Okay, I'm gonna take question or comments, clarification from Natalie, and then we'll ask for a second on the, to see if we can move this motion.
Sorry.
Natalie?
Oh, so I was actually going to make the same friendly amendment. So we're good there. I will second it.
Okay, great. Neil?
Yeah, I'm just looking back at this group's previous minutes, and there have been quite a few resolutions that this group has agreed on vis-a-vis the bar exam. So I don't know if we're trying to incorporate those. If we are, it should be recommendations instead of recommendation, single, right?
Donna, you have an S on blue ribbon commissions the second time you use it. Plural, it doesn't need to be there. Okay. Tracy, is this still a motion you want to put forward in its current form?
Yes, I accept the amendment.
Okay,
Thank
great.
you.
Do we have a second on this motion?
I seconded it.
Natalie did. Thank you. I'm sorry if I missed that. Emily.
So my question relates to the last piece where it says of the revised bar exam. Am I correct then that we would need to revise the bar exam before we started on this path? Is that what this is designed to do? Tracy, I'm asking you if that's what you meant.
I would like it to. Do we need to put a time frame in there? Should we adopt a revised California specific bar exam?
I don't know if you need to adjust it. I just wanted to make sure I understood that what you're trying to get at is sort of Jeremy's point, which is let's do the exam first, then we'll do the alternative pathway.
That's what I like. So if we need to add a time element or clarify that, thank you. That should be in there because that is my intent.
Can I ask for one clarification on that time frame? Are we talking about, as we put it in, are we talking about the need to have the exam before we implement or before we explore?
I think the way I see this is that the revision would be the priority, but the exploring could parallel it. So as you're gathering data and you're revising your exam, you're also in the background keeping in mind what of these identified knowledge, skills, and abilities and these other dynamics, how would that impact this other pathway and ensuring the standardization and consistency?
Because I think that may be, and I could be wrong, I don't know exactly what he meant by it, but I think that may be a little bit different than what Jeremy has asked for in a friendly amendment at our last two meetings. I think, or at least I understood it to be to wait until the exam was implemented, given results to see whether or not you needed it. And I think there was some concern that had been voiced that that's a long time. And I tried to express it again at the meeting. It was a long time to not take a look at this alternative, not that it has to be implemented. So that's why I just wanted to clarify that, Tracy.
Yeah, no, and I appreciate that. I just, again, I think it'd be too much to do both at the same time. So I really do think the focus should be there's already a structure in place, revising, modifying that, but at the same time, you can still explore and gather data as you're moving forward so that you don't have that big time lag.
Okay, well, we'll need to figure out how to get the time element in there that accomplishes what you want and gives clarity to everybody else. Natalie?
So I think I need to withdraw my second then, because I did not understand it in that way. That the one had to happen before the other or some delayed simultaneous exploration. I read it to mean both could go forward, as what I understood. So if that's not what this says, then I withdraw my second.
Okay. Mylin?
Tracy, can you let me know whether there are any other goals that you're trying to accomplish with this over the last one that we just voted down? I understand the timing piece, and it looks like you're trying to tie this more closely, what is assessed more closely to what will be defined through the exam pathway. Is there any other goal that you are attempting to achieve through this version so that I understand how it may differ?
Other than just kind of simplifying, I was trying to go back to just the initial discussion about a general recommendation to the Supreme Court, and that is, exploring an alternative, but not necessarily making that definitive answer yet, because we just don't have enough data. And again, I respectfully state that things are getting really complicated, and testing doesn't have to be this complicated. So I was just trying to kind of reduce some of it. But that's it. And I'll certainly go back to the other motion and work on that. But I think we just need to simplify things and then let the committees and next steps deal with all the specifics. That's it.
Okay, thank you.
Dr. Henderson?
On the matter of when the alternative pathway exploration begins, and I heard Tracy, I respect her judgment on this, but I'm wondering if we could add a short phrase in the last line after the words bar exam to the effect, once its design work has been completed, or once its design has been decided, or something like that, so that the content, the knowledge, skills, and abilities have been decided. So I don't know, Tracy, if that would be acceptable to you or not, but it seems to me that would be a way of getting the exploration jump-started. Thank you.
Tracy, do you want to comment quickly on that change?
Yeah, I think that's fine, because we know what the knowledge, skills, and abilities already are through CAPA. So I think by design, you just, Dr. Henderson is saying like the format, so what's it going to look like? And once you get that piece done, then you can start tackling other things. So you don't have to be necessarily giving the exam. You just got the nuts and bolts in place. Yeah.
So I think that there is still some decision-making around what elements of CAPA to assess. There was a lot of discussion around those more behavioral and performance aspects of CAPA, and whether or not they can be assessed in the bar exam and that kind of stuff. So I think that more specific decision-making about the knowledge, skills, and abilities that the test can assess, as well as format, might be preparatory to any exploration about the alternative. Anyway, thank you.
Okay, well, let me tell you what we're gonna do. We're gonna hear from Natalie. We're gonna ask for a second. If there is not one on this motion, if we're unable to get to a second, we'll ask for a new motion. If we do get a second, I'll take any additional comments, friendly amendments, and then we'll go to a vote. Natalie.
So Malin's question to Tracy was very helpful to me because I understood better what Tracy's trying to accomplish. it sounds to me, Tracy, that your concern is that this alternative pathway that has so many more unknowns might unnecessarily consume the next commission's work. So that's the concern, right? Where we have this other more standard pathway. Would you be willing to consider a friendly amendment? I completely understand the concern that wouldn't force the timeline on the next commission, because maybe the Supreme Court, understanding all of the discussion we've had around this topic, could come up with a composition, both in the experts and the number of people needed, that they could break off the way we did, where we had two like subcommittees running simultaneously so that the one wouldn't hinder the progress of the other, but would both be exploring at the same time with adequate resources. My hesitation is that though I understand the concern, I don't know that it's necessary for us to put that constraint on the future commission if the Supreme Court is able to design a commission that could allow for both to go without one hindering the other. So my friendly amendment is, could we not have that timeline in there and just allow the exploration?
Tracy, you want to comment on that?
Oh, it's a tough one because it really comes down to the different commissions and committees. I mean, I guess there isn't necessarily, yeah. I think I'm going to have to hold firm on this, only because, again, with all the respect to the Supreme Court, they're not testing experts, and I think that you might run into situations where, again, you've got a lot of time and energy going in multiple directions when really they need to be talking to each other for standardization and consistency. So I would like to decline the amendment, but thank you, because I understand your point. And if the group, the commission so chooses not to support this motion, then fine. But I do think one needs to have a little bit more priority than the other.
Okay, I see Jackie and Karen. We're gonna have more discussion about it, but I don't want to spend more time if we don't even get a second on it. So this is Tracy's motion. Let me first see if we have a second in its current form, and then we'll take questions and go from there. Do I have a second on this motion? Okay. Jackie?
I will second it. I will second it.
Dr. Henderson?
I'll second.
Thank you. Thank you, Dr. Henderson, for the second. Jackie, comments?
Yeah, and I think, Tracy, because I kind of hear two things. One that I just want clarity on for purposes of understanding how to vote on this. You talk about a parallel process, that they need to be almost going on simultaneously so that they're talking to each other and there's consistency. And then at the same time, you also say there needs to be a priority. So I'm confused about the simultaneous process and then the priority. So if you could help me understand how that fits together.
Thank you. And yes, apologies for using the same similar words. So again, so the time and the effort, the priority needs to be revising the current exam, because that's the tool that's being used now, and there are concerns about it. But again, once that is moving forward and you've got your design or your format and you're making progress, then the alternative pathway option comes in and takes the pieces that have already been defined by the first steps of the revision, those specific knowledge, skills, and abilities, and then takes that and goes in a parallel manner to that degree.
And just because I want to be, I'm not an examiner, so whoever designs the new California specific bar exam, and they say, just to make it up, 100 multiple choice questions, 2 PTs, an essay, but open book, whatever it might be. And then once they've decided that format and essentially CAPA is dictating content and the abilities and skills that they want to test. Then once that's been decided, just the framework, then you can send the alternative pathway exploration on its way.
Yes, because really, again, personal opinion judgment here is that you really don't, an alternative pathway really shouldn't be needed if you can delve into the specifics of the exam and maybe the issues of concern. And you have a, say, multiple choice exam that is evaluating scenario-based questions, not memorization. If you get away from the rating error associated with essays, that, you know, has been problematic. If you tackle those kinds of testing factors, psychometric factors with the current exam, you may find you don't need the alternative pathway. But again, that's not to say it won't happen. But again, there are many unique dynamics in the current format that I think needs to really be explored. And that is, in my opinion, where the focus really needs to be. So that's why I'm trying to create a little bit of a time delay in the exploration piece.
And again, just to understand the design of the format, it sounds like it would have to be implemented in order to understand whether or not we've solved the problems that you've identified.
Right, in order to have some data, yes.
So it's not just designing the new format, it's actually implementing the new format and getting data on it.
Yes, but I think you could still continue to start exploring alternatives before you actually have that data. I think once, you know, the format is shared and there's more information about the exam, I think that can be part of the discussions for the alternative pathway. You would just have your data after that. Sorry, I'm not as articulate as attorneys as explaining things, but
Karen?
Yeah, I was just going to suggest, and I don't know if it's helpful or not, Tracy and team, I mean, should we say something along once its core design and elements have been decided, or something that sort of indicates that it's I'm trying to help with the sort of the frameworky part of it, because I'm where you are, frankly, that I think there's a way to do this in parallel once sort of the essential elements of the revised exam are understood and sort of its contours a little bit. So just wondering if there's something we can play with there that would capture that thought for the group to consider.
I'm going to go to Donna and we can think about if there's language someone would like to offer. Donna?
Yeah, so 2 points. One, in my mind, the discussion that we've been having about knowledge, skills, and abilities isn't really the point, because this group has adopted a motion. Right, that's the previous among the previous motions that this group recommendation that this group has adopted of what the knowledge, skills, and abilities are. So I don't think we're waiting for those to be decided. It sounds like, right, we are waiting for sort of the design, the core elements of the design, however you all want to talk about it. I wanted to get away from the thought that the pathway, that an alternative pathway would need to wait for the knowledge, skills, and abilities to be developed, because they've already been adopted. So we know what those are. So the question is, do you need to identify, and Tracy was just talking about some of this, identify that it's going to be multiple choice and a performance test and not essay before the alternative pathway is explored. So that was sort of point one. Point two, is if you take a vote on this motion, do we want to add after that California Explore an Alternative Pathway, the phrase from the first part of the recommendation of the motion that Tracy originally gave us, where we add recommends that California explore an alternative pathway addressing the guiding principles adopted by the Blue Ribbon Commission in October 2021. So we're bringing those guiding principles in, so we don't lose that component.
Tracy, you want to comment on that?
Yes, so I love the idea of adding the guiding principles back in there. I would like to do that. The reason why I have the same knowledge, skills, and abilities is because the CAP has identified, this base of knowledge. But my understanding in listening, about the exam is it's so vast that it's very stressful for candidates. And I think that in that vast amount of knowledge, skills, and abilities, and I know we've talked about this in other meetings, again, really understanding which of those pieces are key and the depth of how to assess those. And so that's why I have same knowledge, skills, and abilities, because if you do an alternative pathway, you may not be getting all of those general knowledge, skills, and abilities. So that's why I included that again. What if, though, instead of saying once it's design, maybe once it's assessment format? I was trying to think of words that we use. So when we like assessment format, it's similar to design, but is it, multiple choice? Is it essay? Is it, simulated performance? That sort of thing. So we're the goal would be to really narrow those knowledge, skills, and abilities from the general CAPA to get what's important for entry-level competency. Then you take the format, so you've got this framework, and then once you have that in place, you start to parallel the alternative pathway, and then eventually get data. That would help. That's it. Thank you.
I think there's at least for me, and Jackie was touching on this, Tracy, we're really moving towards the crux of the issue here for some folks. And the timing is important. And you're saying it, I'm hearing you at one point say, it's important to understand the format and that's established. And then we should start, or you believe we should start an exploration, not an implementation, but an exploration of alternatives. But then at the same time you say, and then once we give the exam and once we have data, I find those inconsistent. And so I'm trying to just understand what exactly you're trying to accomplish by the timing.
Well, what I'm trying to accomplish is the fact that I firmly believe that a revised exam would address the concerns that we've heard, and that I don't feel that an alternative pathway is a good option, but I'm trying to find a way to bridge that. And so by focusing the priority of time and effort on revising the exam, again, I think that that would address a lot of the questions, and that by having two simultaneous committees operating, it would be time and effort that may not be needed. So the data would be important for an alternative pathway, but again, I think the data would show that the revised exam is doing what it's intended to, and it would essentially validate it. But again, who's to say? I just think that waiting until the entire exam is done and you have that data would be frustrating for those who like the alternative exam pathway. So I'm just trying to bridge the differences. That's what I'm trying to do, and apparently not doing a very good job at it, but
Okay, well, we're gonna keep moving. Do I have any, so we have a motion by Tracy, a second by Dr. Henderson. Not lost on me that it's the two psychometricians. Do we have any other comments or thoughts from folks before we move towards a vote? Yes, Jeremy.
Yes, thanks, Josh. I just wanted to repeat, you mentioned it earlier about my initial or sort of original intention was that we would wait until, implementation. So just reiterating that that's initially what I was thinking on this. And I mean, this motion seems very similar to the last one we just voted on, except that we've added in the fact that we're referring back to prior recommendations.
Okay, understand. I mean, I think that if I'm understanding the difference, Jeremy, you are correct. And the only other one is this concept around exams assessment format as a timetable. But it's a little confusing for me, so I'm not sure that that's actually an improvement. But Emily, what do you got?
So just one minor thing is that when in the fourth line, the California explore an alternative pathway, I would just say to licensure, so that we're at least talking about what we're talking about. And I'm fine with all of that. I guess to Jeremy's point, and to everybody's point, I don't know exactly if this is good enough for Jeremy and his team, and then not good enough for everybody else. I don't know. So I would just, I mean, one option is to get rid of, and I'm sorry, Dr. Henderson, but to get rid of the modification of once the exams assessment format has been decided and leave it as the revised bar exam to ensure protection of the public, and let the court decide when that point is, knowing that there is a preference that we have some sort of revised bar exam pathway or something, or maybe revised bar exam is too specific, meaning that everything has to be done. I don't know, but I just think we're getting in the weeds on that. And I actually don't know if it's going to help this pass anyway, because if Jeremy and team are saying, look, this still doesn't work, then we're right back at no motion. So.
Okay. Natalie.
Can I just raise one practical point that I think the future commission is going to have to put some I don't know if preference is the right word, or priority in developing the new bar exam, because we will need a new bar exam. The old bar exam is not going to be available to California. So I think there's already that urgency that will exist. I don't know if Tracy, that helps you at all in feeling comfortable that we don't have to dictate that, because I think it's built in with the MBE going away. That has to be developed pretty soon. So I don't know if that's helpful.
Okay, I think we probably need to move towards a vote on this. It's we have a motion, we have a second. I know quite a few comments on it. Let's go ahead and vote on it, and then we can see whether or not we want to move this forward, or we can take another shot at it. Devin, you want to call a vote, please?
Yes. Susan Bakshian,
No.
David Boyd,
No.
Alex Chan,
No.
Charles Dugan,
No.
Jeremy Evans,
No.
Jackie Gardina,
Yes.
Brian Harrison,
No.
Dr. Henderson,
Yes.
Esther Lynn,
No.
Tracy Montez,
Yes.
Judge Reeser,
No.
Natalie Rodriguez,
No.
Kristen Rossi,
No.
Emily Civiletto,
No.
Karen Silverman, Karen Silverman.
Sorry,
Myron?
no.
Okay, thank you. Mylan Spencer,
No.
Amy Williams. Amy Williams. The motion does not pass.
Thank you. Okay, I'm gonna ask, we're gonna keep trying what we can. Is there anybody else that would like to offer a motion for consideration on this subject? Natalie, your hand is up. I don't know if you intended to be.
Yes, I'd like to propose a motion.
Great.
Could the last document be put back up, please?
The one that we were just looking at?
That we just voted on, yes.
Are you seeing it now?
Yes, thank you. Can you just delete the once the exams assessment format has been decided? And I don't think we need to have a whole lot of discussion, but I'd like to try.
Okay, do we have a second for Natalie's motion?
I'll second.
Susan seconded. Okay, Devin, let's go ahead. If anybody would like to make a comment, I'm happy to take them. If not, we're gonna go straight to a vote. Okay, Devin, if you can call a vote, please.
Susan Bakshian,
Yes.
David Boyd,
No.
Alex Chan,
No.
Charles Dugan,
No.
Jeremy Evans,
No.
Jackie Gardina,
Yes.
Ryan Harrison,
No.
Dr. Henderson,
No.
Esther Lynn,
No.
Tracy Montez,
No.
Judge Reeser,
Yes.
Natalie Rodriguez,
Yes.
Kristen Rossi,
No.
Emily Scavalletto,
No.
Karen Silverman,
No.
Mylan Spencer,
Yes.
Amy Williams. The motion does not pass.
Okay, great, thank you. I don't have any anticipation that there are other motions that are coming forward, but I'm going to ask before we move on if there are any other motions anybody else would like to offer one. Jeremy.
Hey, thanks, Joshua. Just I would revise or bring back the motion that I brought in the last meeting in September, which was that, and again, I don't know what the language would look like, but if we brought it back up on the screen, just that we would explore an alternative pathway to licensure after implementation of the revised bar exam.
You had any revisions to this, Jeremy, that I'm sharing from August?
Let me see here. Thanks again for putting that up, Audrey. Appreciate it. Yeah, that's good.
I'm just trying to make sure I'm understanding it. Would it need to say at this time in the first sentence?
Oh, here?
Yeah, I'm not, that's questions for Jeremy. I'm just trying to understand the two, the timing between the two.
No, I mean, I would say no, only Josh, because right after it says it is further recommended. So
Okay.
Yeah.
It's your motion, understood. Do I have a second on this motion?
I'll second.
Charles? Any thoughts or comments from anybody? Friendly amendments? Mylan?
I'm just going to re-ask your question, Josh. I don't understand how those two sentences can be reconciled. Can you say something about that, Jeremy?
Well, I guess where's the confusion? Because I think the first sentence says that we're not exploring a non-exam pathway at this time, but it's further recommended that in the future, after implementation, that we would look at a revised bar exam.
Okay, but I thought you
alternative.
said you didn't want to use the term at this time at the end.
Well, I think what I was saying it is further recommended, right?
Okay. And are we defining implementation once the first new exam is given in July, whatever year that is?
Yeah, I think that makes sense. In the sense that we'd like to have some data after the implementation of that exam.
Thanks for answering those questions, Jeremy.
Susan?
I have a similar clarification to Mylin. I think we need to define more clearly what implementation means, because there is obviously huge amounts of time delay between implementation could be the first time the exam is given, the first time its exam format is agreed upon, voted upon, and approved by the Board of Trustees. Implementation might be the first time we successfully administer, completed, and graded. Implementation might be when statistics are first available for the examination. All of these are very different timeframes. I'm also concerned that Jeremy just said he means data, and if he means data, that's really different from implementation. So I think we need some clarity on what does implementation mean, what kind of data. And also we have inconsistent language in the two sections. I agree with the earlier comments that I do believe these two things are inconsistent without the addition of "at this time." But I also think there's a problem with the first one says non-exam pathway, and the second one says that a bar exam alternative. Do we mean those to be different things? And if not, we should use the same terminology in both.
Thanks, Susan. Yeah, I think those are points. Jeremy, can you address a couple of those? I want to try to just get this as clean as it can, language-wise, before we vote on it.
Of course, no, good questions. So I think my initial thought was that we would have the broader part in that second sentence, meaning that it's an alternative. We don't know whether it's going to be a non-exam pathway, right? So I think that was my thought, whether that's what this group wants or what they vote for, but that was at least my thinking.
Would it be more consistent to use that bar exam alternative in the first portion also?
I don't know. Josh, what do you think?
Well, I mean, look, there's also an issue I want to ask you about, which is the word adopt. I mean, we so far we have not, as a commission, taken the position of asking anybody to adopt or not adopt anything. It's about exploration, and so I'm a little hesitant to make a statement like that. I think it's a little bit out of our mission. But that being said, again, this is your motion, so I want to be cognizant of that.
Right. No, so good point there. I mean, I guess then if you wanted to replace adopt, it might be does not recommend, or does not recommend to explore a non-exam pathway. Since to your point, we didn't adopt anything.
So if we're saying recommends here.
Yeah.
Can I ask a friendly amendment?
Of course.
One real quick, 1 second, Emily. I do want to just try to resolve the. Does it have to do with the inconsistency on the non-exam pathway and bar exam alternative language?
It does.
Okay, yeah, please go ahead.
So the proposed motion is actually combining these two sentences. So Jeremy, you may not like that, but the Blue Ribbon Commission recommends to the State Bar Board of Trustees and the California Supreme Court that California explore a bar exam alternative after the implementation of a revised California bar exam. So we go right, instead of California does not adopt, we say that California explore a bar exam alternative after the implementation of a revised bar exam.
Emily, the irony of that is not lost on me.
I just wanted to capture it so I didn't lose it. So
yeah. Jeremy, how do you feel about the suggested change that Emily's offering?
Emily, you know I love you.
course.
But I think that kind of changes, because I think my whole point was that it would be 2 points. One is that we not explore the non-exam pathway, but that this would, so to me, I think it's important that they're two separate things versus one sentence. It seemed like a small, sort of issue, but at least for me, that's a larger issue, I think. So, no, sorry.
That's okay. Appreciate you considering it.
Jeremy, how did you feel again about at this time being inserted after the word law here?
Again, I mean, and Josh, I'm a reasonable person, but no. And I'm okay if the motion doesn't pass, that's fine, but I at least wanted to put it out there. Yeah.
Did you want to put out, sorry, go ahead.
Yeah, Audrey, I'm gonna try it a different way, because I think I'm understanding what Jeremy's attempting to do. He feels strongly about the first sentence and the statement that it makes. What if we flipped it and said, is further recommended the bar exam alternative be considered in the future after the implementation of a revised California, or even if necessary. I think there's a time frame between the two that's getting really confusing for folks, because you're saying it can't happen, and then you're saying, oh, but it could happen. And so I think that's where the confusion is.
Jeremy.
Thinking. Josh, what was your point about if necessary?
Yeah, I mean, yeah, Audrey, this doesn't work. What Jeremy's trying to do here, it would need some kind of language about necessity. I think we all realize that the division here has to do with a new exam coming in right now, the necessity to see it work, understand how well it's working, and then make a determination on whether or not a non-exam or alternative pathway should be explored. I feel like that's where some of the division is lying right now, and I understand that that's the language we're trying to get in. Jeremy, it's up to you. I would either add in if necessary, or take in the future out, and we can work towards a vote.
Okay. I mean, I definitely think the if necessary language would help.
Be in the future if necessary. It'd have to be considered in the future, comma, if necessary, comma, after the implementation of Rise California Bar Exam. That I think that would that capture more, Jeremy, what you're trying to?
Yes.
Let me take Kristen's comments and Susan's, and then we'll see whether or not we're going to get a second on this. Kristen.
I was just going to suggest, because I hear what people are saying, that the 2 points feel inconsistent, and that I was going to suggest that instead in the second sentence be considered that we put be revisited, and maybe that eliminates the disjunction that people feel between the two points.
That may be a better solution. Jeremy, how do you feel about that?
So I'm just waiting for it to be written out.
And then you just get rid of in the future if necessary, Audrey, and I think that might be a better solution, but we'll see what Jeremy thinks.
Appreciate that suggestion, but I think I would go back to what Josh recommended initially, only because I think the if necessary piece is important if we're revising it in this way to make it one sentence. And again, I understand if the group doesn't want to vote for that, but I think it's important that I at least make the motion.
I wasn't suggesting, just so you know, Jeremy, I wasn't suggesting that you get rid of the in the future or the if necessary. I just was just suggesting that the word considered be changed to revisited, so that the two sentences seem to make more sense when you read them together, as opposed to being, opposed to it, which is how some people felt they were reading.
Jeremy, how are you with that change?
I think revisited is fine, because that makes sense factually, right? Because we're visiting it now. So yeah.
Okay, Susan.
A point of clarification. I agree revisited makes more sense and creates a little bit more interaction between the two sentences that makes sense, but I don't understand what if necessary means. what criteria would trigger the revisiting in the future? I mean, obviously the timing component's clear. Revisiting in the future would mean we won't revisit a non-exam pathway until the examination is implemented. But it's not clear to me what, if necessary, would mean to actually trigger the revisiting.
Yeah, just because I gave the suggestion only in an attempt to try to help Jeremy find what I thought was where he was going. I think revisited actually accomplishes the same thing I was trying to accomplish with if necessary. If it said revisited in the future, if I'm understanding what Jeremy was trying to find, it may accomplish the same thing. But Jeremy.
Yeah, I mean, I guess so. That's a good question. I think if necessary, and again, I get your point of is that data, is that implementation, right? And I guess the question is, do we want to define that all in here or not? I mean, I'm okay with it as is, but understandably, maybe other folks are not.
As is meaning leaving if necessary in.
Correct.
Okay.
Kristen? Jackie?
Sorry, I forgot to lower my hand.
Okay, that's all right. So let's go back. I think it was Charles. Charles, are you okay with you still second this motion?
I would still second this motion, yes.
Okay, great. Jackie, you have your hand up. Is that meaning to lower it, or you have something you wanted to share?
No, I just quickly, I think what concerns me about, I completely understand the need to prioritize. I agree with, I think it was Natalie who said that it will be prioritized just by basis of this recommendation of the Blue Ribbon Commission that we move forward with the California specific bar exam. Not that we explore it, but that we move forward to it will require the state bar and others to work quickly to make sure that we have a bar exam in a timely way. I think what concerns me about this is it does what we are trying to avoid, which suggests that one is inferior to the other. And my hope is that exploring a non-exam pathway for licensure will actually allow us to determine whether or not it's an equal to or even superior way to prepare people for the, or not prepare, but assess whether or not they are competent to practice law. So I'm uncomfortable that this is doing exactly what we tried not to do, which was say one is a better form of assessment because than the other.
Okay, we have a motion and we have a second. Do we have any other comments, friendly amendments, or if not, we'll go to a vote. Emily?
So sorry. Just back on the non-exam pathway, when we, and maybe this doesn't matter, but in the first sentence, we're saying does not explore a non-exam pathway. So if the pathway to licensure has supervised practice and an exam, is that something that we could still explore? Does that make sense? So, or would you rather it say bar exam alternative in both places?
Yeah, good point. Yeah, I think maybe that I would agree with that clarification, because I think that's, I mean, if I were voting in the future on this, that's where I would be, right? Yeah, so I think that makes sense.
Okay, and then the other thing I would say is, I actually like going back to adopt instead of exploring, but if explore is where you want to go, that's fine. Because I do think that there may be, other opportunities to work with other states that are exploring a bar exam alternative that's like, some sort of something that all the 50 states decide to do, or there's a federal something or something like that. So anyway, and maybe I'm just thinking too far out. So I would stick with adopt, but if we're good with explore, I'll stop there.
Jeremy, that's up to you. If you were more comfortable as your language to adopt, let's go back to it.
I think the way that, I don't know, Emily, does this work better if we remove recommends from after commission and then put that down? So where it says, so it basically says does not recommend adopting a bar exam alternative. Is that what you're saying?
Yeah,
Okay. I feel like we're in English class again. And I would put that down, yeah. At the second part of the sentence, yeah.
Well, wait. I still, it's probably still adopt then, right?
Yeah, and then I would move that does not recommend to where it says it, like to the adopt part of the sentence. So that way it if that makes sense. So it would be the Blue Ribbon Commission to the State Bar Board of Trustees and the California Supreme Court. And then recommends not adopting bar exam alternative. Okay, yeah. Yeah. Does that make sense, Emily?
well, no, I mean, just to wordsmith this like way too much. I think what you had was fine. I would just take explore out and put adopt.
Okay.
So, because we're still trying to say it's to the State Bar Board of Trustees, and we can't really do that without putting recommends in the first sentence. And again, we have 8 minutes, so I don't know, we could just vote. I mean, I think we get the
Yeah, we're
essence
gonna
of
get
it,
there,
but-
and we're gonna stop on time.
Yeah, and I got a dentist appointment at 2, Josh.
We're wrapping up no matter where we are this time. Okay, do you want to just look at that language? Jeremy,
Okay.
how are you with that?
Let's see. Let's see. That's fine.
Charles, you okay with the change in the language? You still second the motion?
I still second the motion.
Okay. Any other comments, thoughts before we go to a vote, friendly amendments? I want to let everybody know we're going to go to a vote here. If then we'll wrap up no matter whether it passes or not, and talk about the next meeting. So Devin, let's go ahead and move to a vote.
Susan Bakshian,
No.
David Boyd,
Yes.
Alex Chan,
Yes.
Charles Dugan,
Yes.
Jeremy Evans,
Yes.
Jackie Gardina,
No.
Brian Harrison,
Yes.
Dr. Henderson,
No.
Esther Lynn,
Yes.
Tracy Montez,
Yes.
Judge Reeser,
No.
Natalie Rodriguez,
No.
Kristen Rossi,
Yes.
Emily Scavoletto,
No.
Karen Silverman,
No.
Mylan Spencer,
No.
Amy Williams. The motion does not pass.
Okay, thank you. All right, folks, I know that this is not easy, and we have tried on a number of occasions really hard to find some consensus around the language. We are out of time at this meeting. We'll put out an agenda for the next one and figure out at some point here, if we can't come to a consensus, what our agreement's going to be, what language we're going to use to send back to the Supreme Court. But in the meantime, we have a next meeting scheduled, I think in 3 weeks, Audrey?
November 3rd.
November 3rd. So we will attempt to have a conversation about this a little bit on November 3rd, but we're not going to belabor it if we can't get there. We'll move on to other subjects and we'll keep going. So I appreciate everybody's forthrightness and hard work and willingness to try to find common ground. And we'll keep going at it. Thank you all. With that, I think, Jeremy, did you want to say something?
Yeah, I just wanted to just say you've been awesome, Josh, just leading us, and appreciate your efforts, and just this is a great group, and it's been nice to see everybody, at least when we disagree, to at least be able to smile about it. So that's good. By the way, on that November 3rd date, I might be on a plane, so I might miss that meeting, just FYI.
Okay, thank you for your comments. I think with that, we can conclude. Devin, is there any other business we need to go over?
We do not.
Okay, great. That'll conclude the meeting for today. Thank you, everyone.
Thank you.
Yeah.